Yes. My lord, seeking a loss of indemnity in respect to item 12. Admission matter. Okay. I have got the consent of others that they are agreed to. There is some talk going in between the party. So maybe come after vacation.
After vacation,
After.
council. You're for the other side.
I am for the, yes, I am for the respondent.
Respond. That's for the learned counsel for the respondent submits with the consent of the other side that the matter may be adjourned today and posted after the autumn vacation. Prayer is allowed. Should I fix a date?
After vacation, something continue.
Please the matter after autumn vacation. I'm not fixing a date. If it gets late, we'll make a mention.
Much obliged.
Madam, there is an order dated 2nd of September, madam. Fixing this matter, madam, maybe after 2 weeks. So may I pray, madam, maybe taken about 19.
Which matter? Item?
In fact, it's not in the list today, madam.
Okay. Okay.
I
It's not in the list.
Yes, yes, no. I am praying for on 19th, madam. On 19th of September.
Okay. It is already directed to be listed.
Yes, yes, yes.
It should come, I think. Shall it come? Don't you think it will come automatically?
I think it's may not be, madam. So that's why I'm.
If it is fixed, it will order.
After 2, this is order is
So after 2 weeks, I have not fixed the date.
Yes, yes. No, that is not there.
Today the file is also not there.
But that is not in the list.
List.
Yes.
Make a note. AB number.
Every number is 20. I'm mentioning, madam.
Okay.
Yes. I'm making it matter by the way it's mentioned.
Okay. Mentioning AB number. So and so. Wait for which was directed to be listed after 2 weeks. But learned counsel mentioning the matter of praise for listing it on 19th. Please. Order. Come on, 19th. Yes.
Item 31, Lassi.
31.
People plan to contact Lassi.
Interim is there.
No.
Item 31. Request for adjournment for the day. When should I fix it? After how long? When should I fix it? Date. In after how long I should fix it? You want to fix it after some time? After a week? After a week? At least after a week on next Wednesday, 17th. 7th. CD is available? You want to send it back? In the meantime, the CD though receipt stated to be not updated, may be sent back and the updated CD procured. Can you switch on your microphones? Just check that that's.
Means I'm looking for listing the bail application file today. Like the matter is petitioner wife has committed suicide on 10/7/2025. And certainly on 9 of this month, he has been arrested by his teams.
Anyway, that's not a listing, but can it be before this court?
Before this court, because the punishment is above 7 years.
Above 7 years. Below 7 years. But just check. Otherwise, you can mention again at 2 o'clock.
Yes, I have.
The senior bench probably it may be for the senior.
Because in this in rotation, my lord, I have seen, my lord, above 7 years, these courts have been.
Yeah, there was one stone on that. These practice directions, I am also learning. I have no problem. I'll accept that position. If I can.
Friday of close, my lord.
Friday is a holiday.
It's fine, tomorrow. How much?
I beg to mention item number 35 also.
In this case, Lordship, case diary was called for, Lordship. I'm already on interim. Case diary is not available.
No receipt. Case
So
diary
let
not-
come up after vacation.
Case diary not received. Stop. Since it's interim is there.
Yes.
It should not be, it need not be that long. When should? No, after vacation. So long.
Because these days, Lordship.
25, the last 2 days, I should not fix too many matters. What is the allegation? Alleged offense? No, I don't want to bother you much, but just generally, don't you think after vacation will be too late? Yes. Anyway, let's take a chance on 24. Yes.
Interim order will continue.
Interim order dated so and so. Sir. They'll continue till the next date of listing.
Maybe. So I need to mention item number 37, my lord. I have also similar prayer number. Interim is there, probably CD number. Item number 37 in this case already subject.
We can take up also. We can take up or scan PCR as to.
No, yeah. Interim is there, my lord, that might be extended till the appearance.
Oh, no, it has to be disposed of in some way or the
Yeah.
other. Right? Interim bail. So matter is not, there has to be some final order in the bail petition disposing it off. Right? Cannot be kept in the stage of this thing. Only, if you can wait, let us take up. When
Madam.
it comes up, then we'll take a decision.
Malam.
If necessary, we'll adjourn it.
May I please, your Lordship, madam? Lordship, I beg to mention for listing of the bail application, Lordship, it was fixed as part heard matter before this honorable bench, Lordship. It was listed on 21/8/2025 before the Honorable Justice Mr. M.K. Kolita, sir, Your Honor. But the matter was again referred to this honorable bench. Currently, the matter may be taken on tomorrow, Lordship.
it was-
Part heard matter,
It was
Lordship.
referred.
Yes, Lordship. Tomorrow, Lordship.
Part heard matter, what's his part heard?
Bail matter, Lordship.
Justice Polita had.
No, Lordship. Your Lordship has taken that matter as
Oh.
part heard, Lordship.
Tomorrow?
Much obliged.
Sure. I'd like to mention item 36 for withdrawal. The petitioner has already been arrested in this matter.
Actually, this has become infractions.
Yes.
Right? 26. The learned counsel, your good name,
Ms. P. Bora.
learned counsel submits that due to arrest of the petitioner in the meantime. The extent bail petition has become infractious. The bail petition accordingly stands disposed of as infraction.
Obliged, Lordship.
May it please your Lordship, Lordship, I beg to mention for listing of a bail application for tomorrow, Lordship. Lordship, one analogous case is fixed tomorrow, arising out of same FIR. As item number 34. You should kindly for tomorrow, Lordship.
May it please your Lordship. Lordship, I beg to mention for listing of an anticipatory bail, Lordship. Lordship, there is a long pending matter. Also, there is no interim, Lordship. And on the last occasion, it was on 3rd September 2029, but due to paucity of time, the matter was not reached, Lordship. May it come up tomorrow, Lordship. Obliged, Lordship.
May I please, your Lordship, I beg to mention item number 14.
40.
14. Due to some medical emergency, the engaged counsel is out of this station. The CD was called for and CD is available.
CDS come. CD has been received.
Can you list the matter on Monday?
Current council seeks an adjournment due to medical issue of engaged leading counsel. Prayer is allowed. Case diary stated to be received and shall be retained. You want a specific date? Monday,
Monday.
15th.
Yes.
List on 15/9/2000.
Much more. May it please, your Lordship. Lordship, with the consent of the other side, I beg to mention item number 52, Lordship.
Item
Here is 52. After vacation.
a very old matter.
Lordship. After vacation, I need that. Lordship.
Why don't you do it?
Lordship.
Then do it. I'll force you, but should we keep it just like that? Maybe you may change your mind. And, let's
Lordship, I
keep
need
it.
that.
Let us keep it. Very old matter. If that time may not permit also.
Lordship.
If it permits, then let us keep it open.
Lordship, then any another day, Lordship, because I am not prepared for Lordship.
You will be doing that. Your
Lordship, Lordship, Lordship. Any day, Lordship.
these days are also tied up, so it will be nice if you can try it before vacation.
Lordship.
So old matter,
Lordship,
12 matter.
Lordship.
So can you suggest a date as per your convenience?
Lordship, can it,
16. You have the weekend also. Okay.
Lordship, can it be on 18, Lordship? 18,
18, it's Thursday.
Lordship. 8. Oblige, Lordship.
May I please, your lordship? But this revision was fixed last week, but it is not yet listed, but that's why I'm praying it may come up tomorrow or day after tomorrow.
A revision of admissions next.
Yes.
Admissions,
No, yes, admission.
admissions next. So,
Tomorrow, then the
day after is a holiday,
yes,
day
Friday,
after is a-
Monday, it will come Monday.
Monday.
Regarding item number 33, I have been informed by the local council that charge sheet has been submitted. It's not verified. If my learned friend can obtain the instruction manner, if charge sheet has been submitted, then it can be closed now.
Should we do it now or wait for the matter?
Whenever it's convenient for my learner.
You get the instruction. That's when it comes up.
Sir, can you take that's for a day of fairness, offered granting regular bail to the petitioner. So that this matter maybe what about the city matter? Sorry, police station.
You are Mr. It's called
RIVM.
RIV. Sorry, Council. Additional people. Call for the case diary of Chanmari case number 195 of 2025. The accused is stated to have been arrested on 3/8/2025. List on. 17/9 of life.
Wait, your lordship. The regular bail on 483 minor. Your lordship minor already minor done for the kind of last year, minor.
You are the arrested, one of the arrested.
One of the arrested minor, I made my submission. Your lordship kindly minor hearing for relief for a woman minor. He was arrested on 4/9. Until then, he will jail and there is a police remand for 2 days. That is also been over minor. And he is the man minor, who is minor handling the financial matter minor. And because of his detention minor, entire project is been down when it's stall minor. They stand still minor. And why I'm submitting minor, the lordship can see there is the road that is minor, Talapahar road minor, that cycle factory road, that leads to the Borsapara Stadium minor. And then was that Borsapara Stadium going to held the minor World Cup from 30th of this month. So if minor, everything will stand still minor. And his minor already minor, only the vicarious liability. Your lordship kindly see, he has been arrested minor and he is languishing in jail minor. And now, my lord, your lordship kindly see another inspect of the matter, and I have to be pointed out before your lordship. My lord, that page 54, my lord. My lord, now, my lord, everybody blaming on the company, my lord, they are all playing safe, my lord. But your lordship kindly see that from the record, my lord, Ruth reveal, page 54, kindly see, my lord.
Yes.
Page 54, your lordship kindly see here. Observation recommendation there. Status report of the joint inspection under construction of the flyover GNB and cycle factory regarding the public safety. There's a report, one is 5/8/25, one is 16/8/25, another is 25/8/25. Your lordship kindly see there are 3 column, my lord. As your lordship got, my lord, they are
Yeah.
different, that, my lord.
That's-
Now, my lord, your lordship kindly see the status of 16/8/2025. That is, my lord, in next page, my lord. Page 55. Middle column, my lord, that is a status report of 16/8, my lord. The cycle factory flyover electric barricade has been observed along with the flyover as well on the open drain in the footpath. That is already observed and that is there on 16/8/2025. Now, my lord, your lordship kindly see. So again, my lord, that right hand column, my lord, the observation dated, my lord, 25/8/2025. Right hand column, my lord,
And page 55.
page 55. In the cycle factory flyover, largely barricading has been found along with the flyover as well as the open drain in the footpath. The main concern from today's inspection is the presence of the pothole and water logging. So that was only in, my lord. So everything is there by the end of the, my lord. There is a photograph also, my lord, done by the company, my lord. That is an inspection report clear. That is an inspection report, my lord, made by the disaster management. Your lordship kindly see that last line, my lord. Last line of the page 57, my lord. They are satisfied, my lord. This is the inspection, joint inspection by the, my lord, disaster management and district commissioner, my lord. And in 57 page, my lord, your lordship,
Yes, I'm on 57.
yes, my lord.
Potholes and water logging.
Yes, that is, my lord, in respect of the, my lord, NB. Kindly see, my lord, note of, my lord, the major issue that has been engaged today, pothole and water logging on the GNB flyover. Not, my lord, not then the cycle factory flyover, my lord. And, my lord, your lordship kindly see that so far as cycle factory is concerned, my lord, that is, everything has been taken care, my lord. So now my submission before your lordship. Your lordship kindly see that person in jail, my lord, and as a result, the entire project is standstill because no labor payment. Now, my lord, it will be ultimately when the public will be affected. And also puja is going on and that tap route is very much busy in puja. And that is the only route to lead to the, my lord, Borsapara Stadium. And we are going to hold the World Cup on 30th of this month, my lord. So considering that aspect, my lord, his custodial detention, my lord, already, my lord, demand query is also over, my lord.
It has already been called, right? In some connected matters.
Connected matter, my lord, that is in the respect of years, periods. This is, my lord, 430.
Should we fix the same date?
No, my lord, your lordship kindly prior to that, my lord. You know, can it be on Monday, my lord? Because it is from Ambari, my lord, Patakil Ambari.
That is fixed on.
19. So may I pay that in the Monday because it is, my lord, already regular bill. On 16, my lord, or 15, my lord,
16 also.
my lord.
483 bail application. Patasil Ambari PS case number 127/25. The accused stated to have been arrested on 14/9/2025. Custodially examined and presently in judicial custody. Third, senior person. And learned additional papers. This learned counsel. Praise for interim bail. Or on the other hand, the learned prosecution seeks only the case that he had mistakes. Submitted by the learned senior counsel that the petitioner, the accused was looking after the finances of the company. And due to his detention, the activities of the company have been affected.
The complete project is under extensive.
Call for the case there from the concerned police station. However, in the given facts and circumstances, the prayer for interim stands rejected. Fixed on 16/9/2022 for case there.
May I please, your lordship? Lordship, after filing this petition, I came to know that this case already been charge sheeted.
My lord, let the petitioner be appeared before the learned trial court shall consider the regular bail in accordance with the law. Oh, my simple prayer.
Mr. Hussain,
Huh?
your good name,
ATM Hussain.
ATM Hussain, Learned Counsel. Submits that in the meantime, perhaps charge sheet has been submitted in the case. And therefore his limited prayer at this stage is that the petitioner shall appear before the learned court below and seek regular bail. But additional people, the said limited prayer is allowed. This anticipatory bail application is disposed of with the direction that
And my lord, and learned court below shall consider the bail petition in accordance with the law.
yeah. What are the provisions under which it has been signed? Charge sheet. Sessions tribe 302. 302. Magistrate might have some problem. Anyway. Application is disposed of with the direction that the accused petitioner shall appear before the learned court below. Concerned learned court below. And seek regular bail, which needless to say shall be considered and disposed of in accordance with the due provisions of the bail petition stands disposed of under aforesaid terms.
Obliging.
So I don't want to praise the petition. Also, the sections are bailable also.
Sir, so, borderline. Submits that is no longer pressing for this petition. Accordingly, the instant petition is disposed of as not pressed.
Since the sections are bailable in SR death.
Anticipatory bail is not necessary.
Lords. Oblige, your lords.
Well, right, petitioner is a postgraduate student of the Guwahati Medical College in his Department of Pediatrics. But he also is aware of the fact that the child fell down from a tray and died back. And he was a second year student, and the responsible sister has been taken into custody. And I came to know that he is also enlarged on bail from the court. And now 105 has been added against me, but 105 will not be applicable. It is a clear case for 106 . 106 when the cause of death of a person by doing any negligence act or amounting to culpable homicide shall be punished with imprisonment either a escape for a term which may extend to 5 years and shall also be liable to fine if such act is done by a registered medical practitioner while performing medical procedure, he shall be punished with a imprisonment either a escape for a term which may extend to 2 years and also liable to fine. In this case, yes. In this case, the person has got no responsibility. He was on duty, roster duty, and the sister, and it is the negligence of the sister. 3 child were taken into one stray. As a result, 1 child was fall down and ultimately died.
Nobody will take responsibility. The sister will say that it's doctor's fault. Anyway, so co-accused has been given. Learned. Doctor retest seeking pre-arrest bail. Obligations will have. All for the same case direct. Yeah, the learned additional people seeks only the CD at this stage from opposing the prayer for interim protection. They submitted at the bar that the arrested co-accused has been released on interim bail.
No, the regular bail from court below.
No, the nurse.
This nurse.
Nurse was granted interim bail. 1 nurse I get, I do not from this court.
Then maybe.
One arrested, then maybe more arrested. One of the arrested co-accused has been granted interim bail by this court, semicolon. Another named co-accused was also granted interim pre-arrest bail by this court while calling for the case direct. We can fix it on the same day. Yes, we can fix it. Call for the case direct. in this case also. However, in the interim, with one single choice also.
What is the amount of interim bail of
25,000.
obligation?
Should be same, but I don't remember. But what I
Within 7 days, I will appear, I will give you statement.
25. Subject to the conditions. A date should have been same. Can you find? Date two can
Yes,
just
yes.
find out after some.
Development.
It'll be convenient for you also. Comes up on the same.
May I please request? Worship, I've had it at case 9. Okay. But I'm not named in the affair. I'm Iran said, and named accused is Aminul Islam.
Is there?
Till then, Lordship, I will.
Third, Roman, strict learned additional people. The gist of the allegations in the Azahar dated 25/7/25 is the theft of about 21 bags of betel nut kept in the house of the named accused person, Aminul Islam. Call for the case that allowing the prayer for interim protection. Upon considering the prayer for interim protection made by the learned petitioner counsel, I take note of the fact that the present petitioner, namely Iran Hussein, is not named in Azhar. And therefore, he can be given an opportunity to record his statement before that. Call for CD. However, in the interim, in the event of arrest, standard 25,000 with 1 year satisfaction of the arresting authority and subject to the condition that he shall cooperate investigation. Semicolon, appear before the IO for recording his statement. Semicolon, shall not hamper or tamper with evidence. List, when should be listed? Late. Just keep a check. Last 3 days, we cannot overload actually because it may be all motion days, but we have to keep a check.
Application because series from 17 to 24 and
Yes, both cases. And this cannot be fixed in normal course in the vacation banks, right? Can it be? No. So.
one.
The practical problem also for the dates, but at the same time, if some materials emerge, which require in the meantime, different view, then it can get prejudiced. But we can't help it. Okay, which date? 15/10.
So, Lordship, would you pass over the time being?
Time?
Anticipatory bail application. The Lordship will kindly come to page 10, which is the FIR. May I read the FIR? Sir, with reference to the subject cited above, I have the honor to inform you that on 17/8/2025, NACA checking duty has brought one suspected Pulsar so-and-so motorcycle bearing registration number so-and-so, which was detained during bypass NACA checking on NH 29 Manzarilai Road On further verification, the aforesaid vehicle has brought to Manza PS, and it has come to light that the chassis number of the aforesaid motorcycle was tampered and engine number did not match with the registration certificate, which was produced by the rider of the motorcycle, namely Abdul Muttalib, son of so-and-so, address so-and-so. During inquiry, a prayer was sent to DTO Cardi Anglong to find out the actual owner of the motorcycle bearing engine number so-and-so, and also collected the ownership details of the concerned DTO. It is found that the registration number of the motorcycle is AS21M9837 and the owner is Abdul Malik, which was mismatched as the original registration number put on the motorcycle is so-and-so. As for the statement of the suspected person, namely Abdul Muttalib, it was revealed that the motorcycle was purchased by one of his brothers, namely Abul Qasim, from one Imdadul Hussain so-and-so with a value of ₹40,000. During inquiry, it is clarified that the chassis number of the detained motorcycle was found to be tampered and it raises serious suspicion of illegal activity, including theft, fraud, or forged documents for the purpose of cheating. It is suspected that the motorcycle may be stolen or used for unlawful purposes. However, this bike was recovered from Abdul Muttalib. Abdul Muttalib says that it was purchased by his brother Abul Qasim. Now, both Abdul Muttalib and Abul Qasim have been arrested and they are in custody. We are forwarding.
And Abul Qasim said that he purchased it from
Imdadul, from the petition. Now, the petitioner. Now, your lordship will kindly come to page 5 of my petition, look, para 9. The
Page 5.
Page 5, para 9. The petitioner before your lordship, he is a third-party recovery agent working for Bajaj Finserv, the finance company. Now, this bike, the original bike was financed from Bajaj Finserv. And when the original bike owner, that was Abdul Malik, he failed to pay the EMIs. So Bajaj Finserv employed this Imdadul Hussain to recover as a recovery agent, he was supposed to either recover the EMIs in failure to collect the bike, which Imdadul Hussain did. Subsequently, this bike was sold to Abdul Qasim, and then Abul Qasim's bike was used by Abdul Muttalib. So the change or tampering, whatever was done by Abdul Muttalib or Abul Qasim for whatever reasons is best known to them. As far as Imdadul Hussain is concerned, he was working as a recovery agent. So his role was confined to recovery of the bike, failure to pay the EMIs now. EMIs were not paid and the bike was recovered and was subsequently sold off. Now police, because he has also been named in the FIR, and the police has been calling him. He is otherwise willing to cooperate with the investigation and produce all. Now because police is searching for him, he is even unable to produce the relevant documents to show that Bajaj Finserv had engaged for this matter. So if some interim protection is provided, my lord, he will appear before the IO and produce all the relevant documents to show how he was employed by Bajaj Finserv, that the sale letter was also signed and executed by the original. All of these documents he can produce.
Question. CD would be necessary.
This is not denied now. The fact that this bike was sold by me, acting on the instructions of Bajaj Finserv, we are not denying that part. We are admitting that part. The role, whether it was done on his own capacity or whether it was Bajaj Finserv who had engaged him, that is the only thing which is to be investigated. If some protection is given,
Let him assist the IO in finding that. Word was murdered counsel for the question. Application number 482 BNSS seeking anticipatory bail for this petitioner Imdadul Hussain connection with Manza PS case number 20 of 2025 under so-and-so section BNS. The FIR is dated 19/8/2025, lodged by SI Abdul Rafiq Sikdar. So the allegations in a nutshell is that on 17/8/2025 during a Napa checking, one motorcycle bearing registration number ES02A P0158 AP0158 was detained, and some discrepancies were found in the engine and chassis number. And the rider of the motorcycle was one Abdul Muttalib. Subsequently, upon inquiries with DTO, the actual registration number of the motorcycle was primary facie found to be AS21M9837 and belonging to one Abdul Malik. both these persons were arrested. And based on his, it emerged from the statement of Abdul Muttalib that motorcycle was purchased by his brother Abdul Qasim from the present petitioner, Imdadul Hussain, for 40,000 dollars. It is alleged in the Azahar that there's suspicion about the two-wheeler being used for illegal activities or being a subject of theft.
Here's one thing, madam. Here, another thing is that, madam, there is the capacity, madam, the motorcycle was, madam, the number of that motorcycle and by the gas part of it.
Yeah, it was different. Somebody changed it. Somebody changed it. So that is true. There's some linkages which I found out. The learned additional people praised for the case diary at this stage from opposing the prayer for interim protection made by the petitioner counsel. The Nawaz learned counsel to the petition, drawing my attention to para 9 of the bail petition, submits that the present petitioner is a professional third-party recovery agent of finance company Bajaj Finserv, and that as part of his lawful duties, he visited the house of the registered owner to recover EMIs, but unable to clear the dues, the said owner, Abdul Malik, gave the vehicle, and thereafter, with proper authority, it was sold to Abdul Qasim for rupees 40,000. It is stated and submitted that subsequent to such development, the present petitioner has no knowledge about any involvement of the two-wheeler in illegal activities. And that given the opportunity of interim protection, is willing to appear before the IO and with documents and record his version of events. Call for the case diary from the concerned police station. However, the circumstances finding some force in the submissions of the learned counsel, it is directed in the interim that the event of arrest 25,000 considered, subject to the condition, shall render cooperation to the investigation. Appear before the IO for recording his statement, not hamper or tamper with evidence. List on when should we fix it? First, we also have the last couple of dates. We have to be careful for overload. Because it will be filed. This is of course a problem, but we can take it some. It's other day. It's 24. Should I? 24.
I'm developing.
The last 2 dates, especially 25 and 26. Yes.
I'm developing.
Well, the petitioner and the informant both are working in the ONGC camp of Dhorai in the district of Kachar Mallet in the 2015 Mallet. There is a marpit, and then as a result of which, well, subsequently this person Mallet died, and both are from Tripura. And Mallet now after 10 years, charge sheet has been filed. I have been served with this summon Mallet, and through lawyer Mallet, I have submitted an application on last occasion. And and prayed for time, my lord. Now, my lord, I want to appear, my lord, and to face the time. I pray with my lord. Next date is 30/10/25. On that day or before that, I can appear, my lord, and pray for regular payment. Kindly give me some protection, to appear.
But you appear before the learned magistrate.
Not in the session. Yes, chief justice.
Then won't be able to grant bail because of 302. 302 magistrate.
But your lordship give direction, we can appear and to consider my bail, my lord.
Consider the regular bail.
Regular bail, definitely.
Because 302 directly capital offense. That's 437 that leave.
I have come under 482, my lord. Yes, 482 and
Earlier
bail.
437.
After charge sheet also, your lordship can grant bail. There are series of judgment, what High Court and Supreme
It
Court.
can be. I can grant anticipatory bail here. But
Yes,
if I
that's-
direct them to appear
Yes,
without bail, then the magistrate may not be able to give bail because 302 is there, not because of the sessions tribal. Sessions tribal one can, but sessions tribal with life sentence or death,
yes.
which is the case here, 302. As you know, sir.
I want
you
little
experience.
protection, my lord. Only I go and so,
Should we dispose of them?
yes.
But either by the police can or the or by the
Because my lord, even if my lord, I have been shown as absconder, my lord, without following the due process of law. There is a judgment of our own High Court, Supreme Court, my lord, how absconder is to be declared. I do not know, I have all never follow all these things, my lord.
There has to be endorsements in the case diary that he made repeated attempts. Police showing absconder is different concept from the court showing absconder.
The state government may call for my lord, your lordship.
DNA is not issued, right?
No warrant, no PM. Nothing, no, only some.
Next day it speaks of minus 30/10/2025. We have 9 months. Minus kindly call for the.
It will be held up and your lordship may give me a protection, I'll appear, my lord.
10 years, quite long time. Anyway, but this was learned counsel for the petitioner. Assisted by. Also heard a also learned additional seat. The petitioner is seeking pre-arrest bail in connection with OLI PS case number 228 of 2015 under section 302 IPC. Within bracket PRC case number 392 of 2024. Dash, which after investigation has resulted in a charge sheet dated 31/5/2023. Within bracket, that is after
10 years,
long gap of
10 years,
8 years, about
15 from 15, my lord.
15. 8 years. Certified copy of the charge sheet have been annexed. As also the copies of the relevant orders of the learned court meeting. The case is stated at the stage of, stated to be at the stage of appearance. Full stop. The learned petitional PP submits that perhaps scan PCR may be called for. However, let me see. I've also perused the dated 26/4/2015. Keeping in mind the completion of investigation. Semicolon, the long lapse of time. Since the lodging of the exam. I deem it fit to dispose of the petition at the stage itself accordingly. It's directed that in the event of arrest of the petition in connection with in this case, he shall be released. He shall be allowed to go on bail of rupees 30,000 with 1 CRG of the liability. The satisfaction of the arresting authority and subject to the conditions that number 1 shall not abscond. Number 2 shall appear before the learned court below. Number 3 shall not intimidate the informant and other witnesses or try to influence them. He shall not otherwise hamper or temporary violation of the bail conditions, right? Entail cancellation of the bail. The bail petition stands allowed and disposed of on the aforesaid terms.
My submission to be recorded for I approve that. Kind of one submission that's such is kind of debit 31/2020.
After 10 years.
8 years. 8 years.
After
I've noted them. Learned additional seeks the perhaps.
Because 302.
Huh?
Because of 302.
Then I am willing to appear, I am want to face the trial.
Submits CCR and also opposes the grant of bail at this stage.
But
Yeah, please, your lordship. Lordship, please look at the FIR in the page 16, lordship. The FIR was lost in the month of August. Particular, the page 16, the FIR was lost on
Page 15.
page 16 is the particular. FIR was lost on 23/8.
You can read it if you want. You want to read?
সন্মানপূৰ্বক জনাও যে আমাৰ গাঁৱৰ নিবাসী দীনেশ বেজবৰুৱা পিতা মৃত নৰেন বেজবৰুৱাৰ ঘৰত আজি বহুদিন ধৰি ওচৰৰ কিছুমান ল'ৰা আহি মদ খাই যোৱা খেলে আৰু মদ খাই আহি ৰাতি ৰাস্তাত মদৰ বটল পেলাই আৰু বহু ৰাতিলৈকে ৰাস্তাত আড্ডা দি অহা যোৱা কৰা মানুহৰ লগত অভদ্ৰামী কৰে। মোৰ ভাইটি অৰূপ আনচাৰী লিচু বাগানৰ ওচৰত থকা নিজৰ দোকান বন্ধ কৰি ৰাতি ঘৰলৈ উভতি অহাৰ সময়ত কেইবাদিনো তলত নাম দিয়া আছামীগণৰ লগত সন্মুখীন হৈছিল আৰু ভাইটিয়ে আছামীগণক ৰাস্তাত মদ খাই তেনেদৰে ৰাতিলৈকে হুলস্থুল কৰি থকাক লৈ আপত্তি কৰিছিল। এনেদৰে আপত্তি কৰাৰ বাবে মোৰ ভাইটিক আছামীগণে খুব চাই ল'ম আৰু সুবিধা পালে জান শেষ কৰি দিম বুলি পূৰ্বতে থ্ৰেটনিং দিছিল। যোৱাকালি ৰাতি প্ৰায় 9 মান বজাত মোৰ ভাইটি ডেকাগাঁৱৰ বৰুৱা চুবুৰীত থকা ৰিকি চৌধুৰী নামৰ লগৰ এজনৰ পুত্ৰৰ জন্মদিন খাই ঘৰলৈ উভতি আহোঁতে ঘৰৰ সন্মুখত ৰাস্তাত তলত নাম দিয়া আছামীগণে উক্ত দীনেশ বেজবৰুৱাৰ ঘৰৰ সন্মুখত মোৰ ভাইটিক আগভেটি ধৰে আৰু আছামীগণে মোৰ ভাইটিক প্ৰথমে মাৰপিট কৰে আৰু আছামীগণৰ মাজৰে কমলেশ্বৰ বৈশ্য নামৰ আছামীগণৰ লগত লৈ অহা চোকা অস্ত্ৰ চুৰিৰে বুকুত আৰু পিঠিত গুৰুতৰ জখম কৰি হত্যাৰ চেষ্টা কৰে। পিছত ওচৰৰ মানুহে ঘটনাৰ বিষয়ে খবৰ দিয়াত মই ঘটনাস্থলীত গৈ মোৰ ভাইটিক তেজেৰে লুতুৰি পুতুৰি অৱস্থাত দেখা পাওঁ আৰু কমলেশ্বৰ বৈশ্য নামৰ আছামীগণৰ হাতত তেজ লাগি থকা চুৰিখন দেখা পাওঁ। মই যোৱাৰ লগে লগে কমলেশ্বৰৰ নামৰ আছামীজনৰ ভায়েকে পলাশমণি বৈশ্য কমলেশ্বৰৰ হাতৰ পৰা চুৰিখন লোৱা মই নিজ চকুৰে দেখা পাইছো। মোৰ ভাইটি বৰ্তমান তেজপুৰ টাইমছ হস্পিটেলত চিকিৎসাধীন হৈ আছে। আছামীখনক মোৰ ভাইটিৰ ওপৰত আখেজৰ বাবে মোৰ ভাইটিক হত্যা কৰাৰ চেষ্টা চলাইছিল। ইয়াৰ 3 persons has been shown as accused in the FIR: Kamaleshwar Vaishya, Polasmani, and Vikas Dekha. The petitioner is the Vikas Dekha. And after filing of this FIR, the police has subsequently filed a charge sheet also, which is page 19. In the charge sheet, the petitioner Vikas Dekha has been shown as absconder. And thereafter, on page 22, on 17/12/2021, the Landed Trial Court below has taken cognizance against the accused person, Kamaleshwar Vaishya and Vikas Dekha. And thereafter, on the next page, 23, on 14.
Charge sheet was submitted against these two.
These two persons.
Two of the FIR
Two of
names.
the-
One of which is petitioner.
One of which is petitioner. And
The summons was issued then.
summons were issued. Thereafter, on the next page, order dated 14/8/2024. In this order, it has been reflected that the father of the petitioner has received the summons, but no steps has been taken, so bailable warrant has been issued. So my apprehension is that there is a section of 307, and it's a session triable offense. And if I appear before the trial court, I have apprehension that I need to behind the bar. I'm ready to face the trial. I'm ready to appear. So at this stage, therefore, I'm paying for a regular bill.
Anticipatory.
Anticipating. I'm ready to appear before the trial and face the trial. But since 307 here, other sections are mainstream, trial by mainstream.
Charge sheet has been submitted against with under what provisions?
Charge sheet under this section,
I found 326, 307, 340.
cognizance has also been taken under those sections. 307 is also here.
Both are shown as absconders. I see. Both are shown as absconders.
But I have made specific statements that police never searched me. And no effort has been made by the police to arrest me at that time, or I was I was in my house at that time. So I'm ready to face that trial. Since 307 is there, on appearance, I have apprehension that I do put behind the bar.
Similar.
The thing is that the order last connects is 14/8/2022.
Thereafter,
And as part of the order, my last date was 21
yeah.
Now minus 25, during the course file.
We don't know.
About the status of that. Maybe PMA, it may be issue. What is the status file?
I have,
Because now minus here, minus that point of time, available.
Some order must have been passed in the meantime. Some order must have been passed.
I have specifically, I have specifically pleaded the lordship, bailable warrant of arrest issued by the court at
Yeah,
paragraph
available warrant was issued, but after that.
has not been executed till date. And I have specifically.
Yeah, after 21/11, no date was there.
No, no,
That we may not be sure.
no.
That order will also the next one. Here we have only 48.
No. 21/11, what happened? Subsequent orders, we don't.
Of 2021 order is.
Bailable warrant has not been executed till date. I have made specific statements.
Not agree. So in this case, we can call for. Maybe give him some brain protection. For completion of investigation. Mr. D. Choudhury, Landed Council for the Petition. A. Bush, Landed Additional People. 482 application. Vikas Deka alias Michael. In connection with case 2 case number 1477 of 20. The present accused petitioner, one of the named accused in an Azahar dated 23/8/2020 regarding assault and causing of injuries to the brother of the informant. The investigation resulted in a charge sheet dated 2021. Certified copy of which have been annexed. Dash showing both the scent of accused persons as absconders. On 14/8/2024, the learned court within bracket JMFC Facebook is pleased to issue BW, fixing it on 21/11/2024 for appearance. Learned Council submits that the warrant has not yet been executed. Third, learned additional people. Call for the scan PC along with case diary, you need, right? Question. You need the case diary also. Case diary. Scan along with case diary, scan PC along with case diary. However, considering the completion of investigation at this stage in the interim, it's directed that the event of arrest allowed to go on bail in connection with allowed to go on bail of 25,000. Subject to the satisfaction of the arresting and subject to the conditions that they shall cooperate with the process of law, not hamper or temper with and shall appear before the planet. You can appear. In the meantime, you can appear.
Yes, on the next date is on 11/11/2025.
11. It's for the report. Shall appear before the learned court below on the next date list. By the time. List. The petition. Was one of the states to Congress of this kind. Now we don't have very many days. Can you suggest a date after?
Immediately after vacation.
15/10. 15/10. 25,000. Ready?
What you require is at page 15. Near you.
Page 14.
15. What you. With reference to the subject cited above, I am lodging a complaint based upon information received from reliable source regarding the Writ concern that During the recruitment process for graduate and postgraduate teachers under the education department, more than 50 candidates have submitted past certificates allegedly issued by Texas Global University, Madhya Pradesh, which are reportedly fake. In view of the seriousness of the matter and its simplicity and integrity of the recruitment process, I request you to kindly register a case and initiate a formal investigation into the matter. Case of the petitioner is that Lordship. All the certificates have been issued by a Technical Global University, Lordship,
Yeah,
and actually,
I've seen. Similar matters have also come. Very good. Just a minute. For the Azhar is the same, case is same,
yes, sir.
right? So I'll come to you. Okay, then please. Can you complete?
Actually, Lordship, I'm recommending this because this has been visiting my place without any notice and have been inquired by my family members, Lordship. They have said that I have been added as a link man. But Lordship, the certificates which has been issued, it's issued by global, issued by government portal, Lordship.
They're alleging you as a link man.
Yes, Your Lordship. I was only additional to for the petitioners that we already on interview. Lordship, they have submitted those. If those certificates are fake, then they have not been on interview. Lordship. My humble submission is that I will be given CD may be called for Lordship. If any incriminating evidence comes against me, my instrument will be considered.
We have already called for the case diary, you know, I don't remember the dates,
Lordship,
but that will synchronize, but I'll go through.
and it should do a page 17 is the recognition order of the university, Lordship. And mark sheets which are given by the university, these are given the government portal, Lordship. If the UTID number is inserted on the official website, Lordship, every details of the candidates can be released. But these are the certificates also issued by the institution, Lordship, which are real certificates. These are only given by the government for the Lordship. And it should 3 series, Lordship, page 18, 19.
I've seen.
And certificates already been sent, Lordship. I may be given an opportunity to appear before the annual.
Yes. Suspected to be fake.
Why police is searching to make that the link can be involved in swing those cases. So my lord, now in this case, where the elucidating certificates, this way my
Para 5,
pair of 5.
so their petition.
Yes. Saying this petition at this point is not a problem for this case.
I think maybe the broad direction of the allegations may be like this. The university does exist, right? Technoclo. So probably the allegation may be on these lines that they are issuing certificates without the candidates actually undergoing the course.
At one time, why something for the other petitions, those submission is there, those documents were also very technical. So my lord, at that point of time, it was also submission that those documents were genuine. Now, my lord, while appearing on behalf of the present petitioner, those certificates were issued by you. You can work with acting as a link bank for issuance of those petitions. So that means that itself the petitioner admitted that those are fake certificates. And while appearing on behalf of other petitioners,
He has been conveyed to his family members that they are suspecting him to be a link.
Because these cases.
You may be justified. You may be absolutely justified in making that prayer. But, do you remember when have you fixed the 90?
Only basis, on basis of suspension, lordship.
Your good name?
Exit.
Ailes on council. The petition. For ending errors. The learned council has taken the court to the FIR dated 31/7/2025. Register the allegations, connected. The learned council has also taken the court to the some of the documents, academic documents, opening to the said university, submitting that these are genuine documents. It has also been pointed out by drawing attention to copies of the annexed orders about interim protection granted to some other persons. Other person in connection with the same FIR, but the bottom learned additional figure who submits that while case diary may be called for, but therefore interim may not be allowed as because the case of the present petition stands on a somewhat different footing. Drawing attention to para 5, the petition. The learned additional PP submits that the police, while meeting the family members of the petitioner, had conveyed to them that it's suspected to be a linked man issuing fake certificates. Call for the case diary from the concerned police station. As regards the said contention based on para 5 of the petition, the said statement at this stage is merely a statement in the nature of hearsay and based on suspicion. Therefore, considering that several other petitioners in connection with this FIR have been granted interim protection, I am of the view that this petitioner should also be given an opportunity to record his statement and assist the investigation. So, in the interim, 25,000 protect the conditions that we shall appear before the cooperate with the investigation, so appear before the IO for examination. Semicolon shall not indulge, misuse its liberty to commit any illegal activities. Semicolon shall not hamper or tamper with means. This on 1909. Instructions, yes.
Yes, no instruction was sought, my lord. We have received the instruction, my lord. My lord, case is registered.
Yes, it's raised.
Case is registered, my lord. We'll move by the law. Then that's it, we will go to the court. By making to the we have then there can be more concept, my lord.
Copy of the FIR.
Yes.
Paragraph 2. Yeah, that's right. It was, I guess. The petitioner was seeking 3 years bail. Regard to FIR dated 9/8/2025.
Here, my lord, they don't know about the regarding the registration of the case. So, the very comprehensive.
Second paragraph. Second paragraph. Full stop. Pursuant to the above, the learned additional people submits today that it has come to be known that a case has been registered. And a copy of the same has been submitted before the court. This is the FIR. A copy of the FIR has also been received through electronic mode. WhatsApp. Within bracket WhatsApp. What are the sections?
Petitioner not NGO. This is my lord, on the petitioner's
Assault.
assault matter. The dispute regarding the land.
Call for my lord, because there are category is stated in the FIR, my lord, that my lord not able to my lord post the FIR on time. Was my lord because of the injury.
Serious injury.
Yes, my lord. My lord, the city will be called for a short date, my lord, from cooking goods, my lord. Maybe in the next week, my lord.
In the meantime, my lord, I will be allowed to appear, to cooperate, so that the case may investigate early.
What is the narration in the Azhar?
Land dispute, or cultivation, regarding cultivation.
As per their statement, my lord, they came with the mind of the things, and the mind of the petitioner was bigger. That was their statement. The other hand, this is the FIR.
Gurutor Assam Kore. Gurutor Assam.
Yes,
Previous injuries.
And not only that, my lord, we are দেউতাৰ হাতৰ পৰা গুৰুতৰ জখম পৰে। দেউতাক লৈ চিকিৎসা ব্যস্ত থকাত এজাহাৰ দিয়াত পলম। So that line is there. So my lord, no interim at this time. So it is sorted by the.
My lord,
Call for the.
police brought the petitioner to the health center, my petitioner also got injured.
Here is the FIR document and the Azhar. Copies of which are received as indicated above. The learned additional objects to the prayer of the petitioner counsel for interim protection. At this stage, call for the case diary along with medical report.
Protected, my lord, petitioner is ready to cooperate.
Interim is not possible. Serious injuries. Yes, natural. 16. List on 16. Oh, yeah, sure. I need not record. Yes. I know. 2 seconds. That's this is over here. It's it, FI and case. Is it who is he?
Assistant Executive Engineer. Public.
Why are they think everyone will be arrested in PW?
Proceed.
Standing picture. Certainly no. They, all the police does that, then they will be foolish. Go pinpointed way, whether it is been made out or not. By whom? Help it. Parity you have to give. They are similarly placed. 2246 of the was very fast. 482, other cell number is placed. 127. Third. Yeah. It appears that some similarly placed persons of the department who were also apprehending arrest in connection with this case have been granted interim pre-arrest leave. According all for the case there in the interim identical. Date too, I don't know. It's on 23/9/25. 23/9/19. Other courts might have also passed. 19. It is reflected as 23/9 also. It's a record, whatever. My one. Okay. So, at least the date came as 23. I don't remember actually what I did. So what should we fix? 23. East on 23. 23 or 9. No, interim. 23. That will go back. If you now we can cross check streaming. No, interim has been granted first time. It's a new page. Or select connectors. And to test track. And I think 90%. I don't know, it's true. Or in the test track. Fiction criminal.
I appear on behalf of the petitioner, Mrs. Manmeet Kokela, and Vikas Hooper in the writ petition challenging the order dated 16/6/2025 filed by the learned judicial magistrate first class of Golaghat.
The habeas corpus. No, not in this page. Not in this book. Habeas corpus. I've not seen it. Can you check the post? Habeas corpus?
It's a writ petition.
Yeah, writ petition criminal. That is pertaining to what? Preventive detention.
No, Your Honor, it's a for non-compliance of under section 223(1) of BNSS.
So you're not filing a bail, you're taking this route. Writ petition, filing a writ petition. Yeah, go ahead, make your submissions.
Your
Government advocate can take it up. Yes. So you just introduce the matter.
Your Lordship, I respectfully submit that the intervention of this honorable court is essential to prevent the manifest abuse of criminal process being inflicted upon the petitioner in clear violation of established legal principle and statutory protection in the BNSS. Your Honor, Section 223 under subsection 1 of BNSS clearly mandates that before taking cognizance of an offense upon a complaint, the magistrate shall examine upon the oath the complainant and the witness, and only thereafter may issue notice after giving the accused an opportunity to being heard. In this instant matter, Your Lordship.
Pre-cognizance hearing,
Yes,
the new provision.
Yes, Your
BNSS.
Lordship. Now the learned magistrate did what? Without examining the complainant and the witness on oath, she issued the notice to the accused. Without complying the procedure of section 223. The learned magistrate failed to observe the mandatory pre-cognizance requirement
in the order dated 16/6/2025 proceeded to issue notice without recording the statement of the complainant or witness. There is no mere procedure irregularity, your lordship, but a jurisdictional error that void the entire proceeding. With the judgment of Karnataka High Court, can I give you one copy, your lordship? The
You are invoking 528 also.
Yes, your lordship.
Basically, it's a,
Quashing idea because
because
the
27 has been given, so it has been
the learned judicial magistrate did not.
criminal petition actually. Effectively, it's a criminal petition.
I will issue you. Your lordship, if you see this Karnataka High Court judgment, it is clearly mentioned that a complaint is presented before the magistrate under section 223 of the BNSS. On presentation of the complaint, it would be duty of the magistrate concerned court to examine the complainant on oath, which would be his sworn statement, and examine the witness present if any. The substance of such examination should be reduced into writing. The question of taking of cognizance would not arise at this juncture. The magistrate has to, in terms of the provision, issue a notice to the accused who is given an opportunity of being heard. Therefore, notice shall be issued and accused at the stage of after hearing. Take cognizance and regulate the procedure. The provision indicates that an accused should have an opportunity of being heard. And subsection 1 of section 223 of BNSS said append to its complaint the sworn statement, the statement of witness is in this instant matter, your honor, if you see from the petition order dated 16/6, page number annexure A of my petition of order dated 16/6, without recording the statement of the complainant or witness, the magistrate issued the notice to the accused person.
Stage.
Annexure A, page number 14 of my petition, your lordship. I'm challenging this order before this honorable court, your lordship. In this order sheet, you can see, your lordship, that the learned magistrate did not record any statement of the complainant and as well any witness. She directly issued the notice to the accused person. On this basis, your lordship, I am praying to quash the matter. If I go to the details, your lordship.
No, you have to serve copy to the government.
Okay, sir, lordship, in the meanwhile, when the copy will be served, I request to this honorable court, my prayer is to put stay in the lower court procedure.
That will consider, but I think can you serve it during the course of the day? So,
Yes,
serve it in the course of the day, and then we can take it up tomorrow, perhaps.
tomorrow.
Tomorrow.
Can you give me 5 minutes? I need to ask the senior.
We can take it up later in the second half.
I'm just letting him know for the tomorrow. Just give me a minute.
No. I know.
Just give me 5 minutes.
To talk to your senior, and in the meantime, you serve the copy also. And then, while serving the copy, you can ask him. The court was asking, if you can take it up in the second half, we'll take it up in the second half. Well, that after he appears, so after the copies are served, then I will consider.
The copy will be served.
Okay, then the second half, lordship, can this matter be taken up? Yeah, that's what I said, second half. Second half. Lordship.
May I please, Your Lordship? Lordship, 19 is a regular bail and 20 is an anticipatory bail, Lordship, and it could be same FIR, Lordship. 19, Lordship, one petition. And he is in custody for last 73 days, Lordship.
19 is the BA, right?
Yes, Lordship, this case diary was received in this case long back, but there was no injury report, or injury report was called for certain, I think number of times there are orders, Lordship. So I want that this bail application should be disposed of to the Lordship.
Was arrested on
6,
30th June.
30th June. As on today, 73 days. 73 days. Other custody would not be necessary, Lordship. Yeah. Lordship will come to the FIR, Lordship.
At
long
page,
it starts from 12, Lordship. It's the translated version, Lordship. the long FIR Lordship. There are a number of civil suits pending between the informant side and this petitioner side. Lordship. And on that day, when they alleged that incident, Lordship, of assault, that actually these persons, they went to visit the relative, Lordship, and there they were attacked. And two persons from our side, Lordship, already died. There are no death, Lordship, on the other side. Our also, we have filed a cross FIR that is have annexed, Lordship. Long FIR, Lordship, all we have alleged stated about this.
Anticipatory is also connected.
Yes, yes. Anticipatory is connected. Lordship is also, see our FIR, Lordship, there we have, there, our FIR is at 629. Only because person died, Lordship, so our FIR is subsequent, Lordship. 73 and there is 72. Our FIR,
One person died.
two persons died, Lordship. One subsequently died in the hospital.
Present city is how it is 72, 25. Along with how it is 73, 25.
72 is against them.
Against them.
And 73 is by them.
Yes. In that 73 case, two persons not be also right? For the incident. One will have one, about this.
With regard to the regular bail, Lordship, consequently length of detention, Lordship, may be considered at this stage. And in the anticipatory bail, Lordship, all these petitioners, they are family members. As they have been implicated. Lordship.
There have been death on their side, your side.
Our side, 2%.
And injuries on the other side.
Understood.
As per the FIR, there's a long history of conflict.
Yes. And this will be what like this will be going on. During pregnancy of
Another-
yes, for one of them. And again, my lord, how long during pregnancy of a very well during pregnancy.
It's never solved.
You also which I just one of the programs. Where the petitioner, yes, it been another. Very good.
He also sustained injuries in custody. 1980.
He's injured.
Please, also been after.
My instruction is there also that on the other side, they have not sustained such injuries.
This is the
70. This is
73, 72 is also very.
this by us.
73 is by us. By you. Investigation is going on. What do you say? What do you submit?
It seems that present petitioner yes.
Petitioner means petitioner or the
Petitioner.
arrested accused?
Petitioner. Arrested accused, yes.
He must be in hospital.
Yes. One photograph of yes being already served.
I've seen.
Yes. Since 25. Otherwise,
In this petition,
yes, remember, Counterfeit case 72, which means that the photographs. Hard photographs of yes being
I've seen. I've seen the photographs.
So, everyone is doing a lot of when this group.
Lot of conflict.
Yes,
In this bail petition, how many people are there? Yasuddin.
here only one.
Yasuddin is injured.
Yes, we need to do. And one other photographs is there, two persons, really is done. That is item number 20, petitioner number 21. Photograph.
And disciplinary bail may not be because of the conflict. Because this person we can perhaps point because he's already injured. Seriously injured.
They are most probably their injury report should be challenged. That one, whether they have sustained such injuries, that further in, we will cooperate, Lordship. All the persons, Lordship, we are from the same family.
Discouraged.
Even ladies are there, Lordship. Aged persons are there. 80 years person is also there.
Bail DA. This is third learned council. And if we got a good learned petition of 483 BNSS bail application. Seeking regular bail for Yasuddin, India's Yasuddin Ahmed, stated to be in detention since this in connection with Kharopikia place case number 72. The case arose out of Ezahar. Regarding allegations of conflict over land dispute, followed by assault, serious injuries. This is 73, right? Oh, sorry, 70.
And those injuries are in 73, so they did by us.
The petitioner side, it is submitted that there is also a false FIR from the side of the accused hearing against the informant side, the present police case regarding such conflicts and assaults. Two persons are also stated to have expired from the side of the present accused in the said conflict. Case diary has been received in 11 portions produced. Investigation has progressed but not yet completed. Some photographs of injured persons, including that of the present accused, is also seen, which prima facie give the impression of serious injury. Though the investigation is not completed, but considering the injuries of the apparent injuries of the accused, apparent injuries of the accused, and the length of detention, yes, he is allowed to go on bail of rupees 30,000. Once you get satisfaction, one, he said, wait in peace. Then you will not commit any offense. So you will not hamper or temper it's violation. So it's return back the case there. The other one is there.
Lordship, in that case, one more submission also. If Lordship comes to petitioner number 16, Lordship, I have NN6 voter ID card also, it is 80 years also. Now they have to remain away from the home also because of these police.
It's all there.
Lordship,
They're all got involved. Primarily, all are got involved, irrespective of their age and gender. I don't think.
and even
Yes.
my friend has already submitted that Amin Islam, he also sustained injuries to us.
Similar allegations. And is that in the action circumstance,
So we consider that we can cooperate with the
did not give it appropriate. In the circumstances and the materials revealed, I do not consider it a fit case for grant of anticipatory bail. Accordingly, the same stands rejected, return back to case now. Both the case lines. 5 minutes.
May I please your lordship?
Any, you wanted to say something?
Yes, lordship, 78 days behind the trial.
Big currency.
Yes, lordship. Lordship, may kindly peruse FIR at page number 18.
That is one option. Would you like to appear before the trial commencing date?
Lordship, the problem is that this case is pending before the season. Section 6 is trial by session.
Yeah, actually, now another thing is there. If this, is it 489C earlier? 489C earlier section. State currency.
Yes.
Because nowadays,
It is suspected things are found from the.
because fake currency cases nowadays have to be investigated by if investigated by the state police, it will be before sessions. If investigated by NIA, it will be before the NIA. Those these fall in the list of scheduled offenses of the NIA.
Yes, this is
Right?
investigated by Assam police.
Well, so it's
So it
before
is pending,
sessions.
it is tribal by session. Now, lordship, my problem is that
There's no need for committal actually. They are, there's this after Vikramjit Singh judgment, citation. So it has been said that all these offences which fall in the schedule of the NIA Act will be investigated either by NIA or by the state police. Okay. So if they are investigated by the state police, then they will be before the special court, and all those states where special court has not been specifically earmarked, like our state. It was a case for Punjab. There also it was like that. Then the territorial sessions court will be the deemed special court. So actually, no committal is necessary. Plus, we had many confusions earlier, so I think it was
with
discussed.
this observation.
Anyway, no, I mean not also. Yeah, for the purpose of bail, actually, it has to be brought to the notice. It has not been sent to the, no committal, just to be straight away sent, refer to that judgment and send it to sessions. I can make an observation anyway. You saw what you suggest. Would you exercise that option of going below and going to the court and seek bail? But there's a problem.
Till committal of the
Before
case,
CJM.
there will be time required. That's why lordship,
I said it's not necessary.
can we dispose of this matter and do it a direction?
Without
This observation.
perusing the materials, will it be prudent to allow bail? Currencies there. No, it may be,
The length of
we
detention.
should see some materials. Please. At this stage only, we have the completion of investigation and like. That also may be grounds. These people are from local people.
Local people, lordship, according to the FIR, these things are found from the behind backside of his premise, lordship. It is written in the FIR itself, lordship.
Let's have
The first paragraph of the FIR, which is at page number 18, the last sentence, I have found the suspected person, Yuan Ali, and his residence, and found the below noted articles on the house premise within bracket backside of on the backside of his premise, lordship. So, lordship, and 78 days, this person is behind the bar, lordship. Backside of the premise.
And the principle of conscious possession will come. Equally. Scan copy, how long it might take? One option is there, but the session style. CGM, I don't know.
It is there. Yes, we. Lordship may call.
Well, quickly call for the can schedule.
Because it is now 78 days.
People here, the document.
Yes.
But just one council for petitioner, whatever additional. First stated to be in custody since 25/6/2025. This it is submitted by learned additional PP there. In the meantime, charge sheet has been submitted. Any further submits that considering the nature of the alleged offenses, tracking, counterfeit Indian currency. Scan copy of the case diary and CS. All PCR is necessary, or only the charge. Scan copy of CS and CT will be produced. According for the scan is there and charge from the portal. List on before petition. Because concerns. Can it be on 22? 22/9.
Obvious, deeply obvious.
Regular bill also. This daily was confirmed. 40. Safety is. Two and 3. 22 and 40. 26. 22 and 22 and 26. No, only 20. Sorry, only 26. No problem. 22. Though the allegation is serious one, lordship, when the CD is here, lordship, what to submit? Statement is available. One of the two named persons. Unknown. Two persons. English statement will see. Statement also see. Statement. Let the injury report come. Injury. It's better, let me have. Yes. So. Landed counsel for the accused and he voted for landed additional people. Accused is seeking regular bail in connection with Procedural case number 395 of 2025 under section 4. The SMR / FIR dated 3/8/2025 was lost by the victim's mother with the allegation that some persons attacked and brutally attacked her and causing serious injuries, for which she stated to be in hospitalization in serious condition. It's further alleged that after regaining consciousness, her daughter stated that 4 persons attacked her. Dash, of which 2 were unknown and 2 were known, being Akhtar Ali and Karimal. The present accused seeking bail is Akhtar Ali. Yes. Nickname Akhtar Ali. The learned counsel clearly submits that the case diary has been received. Findings thereof may be seen at court. Learned additional people submits that the investigation has progressed but not yet completed and has revealed materials lending support to the allegations. The medical report from this hospital appeared indicate piercing injuries and followed by surgical repair. Yeah, or 164 is recorded. Thing. The learned additional people submits that the alleged victim in her statement reported by police has implicated both the named accused persons. I have also perused the said statement. It's part of the case that list before the court. It is alleged by the victim in her statement that due to rivalry with her shop, she was attacked by the assailants. The circumstances are considered through that. At this stage, there might be some apprehensions to safety of the alleged victim. And therefore, the bail petition stands rejected at this stage. Returned like this is there.
Much obliged, Your Honor. Much.
There is no received. Is there not received? Issue reminder. List of. Oblique. Scan copy of PCR was called for. Investigation is completed. Because otherwise he substitute charge sheet.
93 days lordship they have to work.
So we have to wait for the scan PCR. It's submitted by one of the additional people that scan PCR as called for has not been received. So issue reminder. List. Last 2 dates, be careful, last 2 dates. Because many new matters might come. Right? So if in the bail bench or the new bench, matters might come. 24 or something. But he didn't study for a long time.
Lordship, 93 days lordship they have to work. 93 days.
Yeah, that's why I said. Statutory period and charge sheet it is. Otherwise. 20. 28th September. List of 29. 209. Did it in the forwarding. Conspiracy, alleged to be for conspiracy. Have to see the case diary.
Short date.
The case diary along with PM report was called for from the same is not received. Issue press requisition. 20, same. List on 209. But that's why. Oh. 20th September is Saturday. It has to be 19. Previous one also. Previous one. 19.
Number 26 and 40 also arising out of same.
26 and 40.
Item number 26 is regular bail application and 40 is disciplinary. Your Lordship, FIR, your Lordship will find at page 9. They are in custody for 64 days. And the informant is the brother of the petitioners, and this is also brother of the petitioner number 1. 3 brothers.
1 brothers.
3 brothers. This is informant and the petitioner number 1. All 3 are brothers. Very.
See there.
Your Lordship, in the FIR itself, your Lordship will find that Mohar Ali, in between Lordship, 6 line from bottom Lordship, page 9. That is, say that later me and other family members went to the place of occurrence and Mohar Ali caught me and pushed me on the ground. So there against petitioner number 1, it is evident that he quarreled with the informant, not with the deceased.
Petitioner number one is
Umar Farooq and petitioner number 2 is Mohar. Petitioner number 2. But Mohar Ali caught me and pushed me on the ground. On the other side, Mohar Ali's son pushed down Mojid Ali, sat on his head. So that is allegation against petitioner number 1. And against let's say petitioner number 2 only quarreling with the informer, not with the deceased.
just
And there was not a long land dispute is there not since long and so the heat of the moment, not a pre-planned matter.
just government is subtle.
In the first line of the FI itself, quarreling and brother, but
Okay. Investigation. Too much. Injury or harm made. Mojid Ali. Yes. Mojid Ali.
allegation of strangulation is there, whether it is there in the postmortem report or not.
These statements. They are of brothers. Main allegation is against Farooq and the lady. That does not. PM report is there. Okay. You are for the informant? Yes. Saberal. Oh, here also, 22. 40. Same method, take it out. You are appealing for the files.
What matter is the that wife of that petitioner number 2. Sister-in-law of the informed.
Petitioner is
Rukhsana Khatun.
Rukia Khatun.
Okay, Rukia Khatun.
She's one of the name.
Yeah, but simply wherever in a village that quarrel took place, all family members are roped in.
I don't know. Lying, I don't know, but the statement is that he and was the assault.
But whether post-mortem we could disclose that maybe also like I will see.
So water report does not seem to indicate that injuries of lungs, heart. You submit on the anticipatory plan. You can submit on the anticipatory plan. I'm taking up together. Yeah, make your submissions. On the, yeah, 14, we are taking up together. Yeah.
I don't have the copy of the bail application.
Okay.
I just-
After some time, actually, same matter.
Yes, Lordship.
If you are in a position to submit, then submit. Otherwise, you can wait for it.
That I have taken the copy of, 40 is not there, but item number 26.
Contents are same.
Yes, Lordship. Even the main allegation against the petitioner is that he has squeezed the private parts. So which,
Secretary bail may not be very justified.
So, considering that she is lady and whether they injuries are there, the post-mortem that part was in the
He might have died due to the cumulative effect of various injuries, but this kind of injury, I don't know whether they had checked the postmortem. Does not mention, it does not mention.
Yes, she is woman, that can be considered.
But
Actually, section 437 also says that party or women is there, then that can be taken into consideration.
direct allegation. Yeah.
person had died because a very sensitive topic.
Learn also for the petitioner, this petitioner also heard he wanted to learn an additional bit. The from the Azahar logged by one Sabir Al emerges that the informant and the accused persons named therein are family members. And they have been quarreling over land. And on the day of the incident, there was assault on the deceased Mojid Ali, leading to his death. The learned counsel submits that the investigation has progressed and the present petitioner happens to be a woman, where anticipatory bail may be considered. The case diary has been received. The other additional PP points out the relevant portions, including PM report. The present petitioner is named in the fire, with direct allegations against her. So the same also finds support from the investigation materials, including the statements of eyewitnesses. Learned counsel, your good name? Learned counsel appearing for the informed poses the bail petition. Considering the nature of the allegations over the materials revealed and the continuance of the investigation, dash may not be an appropriate case for grant of anticipatory bail at this stage, which accordingly stands rejected at this stage. Return back the case directly. These two persons are in custody since 9/7.
Yes, 9/7 and 17/7. Petitioner number 2 is 17/7.
17/7. Walpara River PS case number 12. Yep. Allegations is same. Both the present accused persons are named in the fire with allegations against them. Here is the relevant portions of the case diary, including statements of eyewitnesses and PM report. The PM report mentions about injuries over head, lungs, and kidney caused by blunt force impact. Semicolon, though the final opinion regarding death is kept pending for chemical analysis report. In the progress of investigation, the accused persons are in custody since their arrest on 9/7/25 and 19/7/20 17/7/2025. The heart learned additional people important to know opposes the prayer for bail at this stage. In the alleged unfortunate incident, the parties on both sides are stated to be members of the same extended family. Considering the progress of investigation and the length of detention, the two accused persons here, namely Omar Farooq and Tracy, are hereby allowed to go on bail of rupees 25,000 each with the surety of the light and image section of the concerned unit, subject to the condition that they shall not abscond, they shall not misuse their liberty to commit any offense, and shall maintain peace. They shall not hamper or tamper with evidence. And they shall return back.
May I please have option?
Yes, they use call for him. They receive personally PM report. 306, 302. It's necessary. PM report is necessary. This one was very for the short. Yeah, was very good. In custody, since 25, about 48 days in custody. PM children assisted by each children. Case diary has been received. Whatever additional submits that those C2 case diary has been received, but PM report not yet received. And submits that the case being a alleged case of homicide, the PM report will be necessary. The said PM report may be requisitioned expeditiously while retaining the case diary. List on Polasbari place. Polasbari place. Okay. 22 minutes.
That's 52 days behind the bar also.
What is the, what are the sections?
That's also 200 take times.
Three currents.
It says 60 days behind the bar.
31.5. Okay, when was the charge sheet submitted? 8.5.
Charge sheet submitted on the
On 28/8/2028. Just before 90 days. 36, 17. Borderline case. May has. Is it, no, was it over when the charge sheet was filed? Manually, it's difficult to calculate. Just check me a borderline case. Maybe on 89 days or something. Date calculator, I can use it. 31.5. He was arrested, sorry, when was he arrested?
Yes, one arrested on 10/7/2020.
10/7, then he don't.
Our main,
Ten's also much later than the date of the arrest. Well, thanks for that.
which is what our main queries has granted bail. Bail order is. Bail order.
But again, the same problem. Trial court may not be. May hesitate because now not only the sessions tribal aspect, as I pointed out, there is not only the sessions tribal aspect is there. Sessions tribal cases, we have two judgments of our high court. Sessions tribal cases, magistrate can grant bail except capital offences. Okay, so but here there's another dimension. I say after Vikramjit Singh's case. Now these cases which fall in the NIA Act schedule, they have to be investigated either by NIA or by the police. If it is investigated by NIA, it will be for the NIA. If by the police, then before the sessions as deemed special court. This is what it will be. So that we can do quickly. Which police station?
Victoria PS now. Main court is has granted bail. There is no 24.
Let me see that.
Nothing was recovered from us. To verify this. Transfer recovered from the death.
He is Mr. Sahil.
And Mr. Faizul.
Fine. This was after Madam at Perus the case there. Case there, investigations. We can maybe take, see the slightly different perspective. So. Charge sheet has been filed against any information, detailed information against two persons, both the accused persons. Third, your goodness.
B program.
B Borgman, B Borgman, B Borgman. Burnett Council, B water to additional B. 483 application. Victoria PS case number 112 of 2025. That's next one. List of the allegations. The FIR dated 31/5/2025 lost by a police official. It's about recovery of fake counterfeit Indian currency for the persons. Present accused stated to be arrested on 9/7/2025. 10/7/2025. He was in custody in another case. Learned counsel has pointed out the length of detention and also drawn my attention to a copy of order dated 12/8/2025 passed by this court in BA 2462 of 25 granting bail to co-accused Sohidul Islam. He Waterford learned additional PP opposing the bail submits that in the meantime charge sheet has been submitted against two persons. Yes, two persons against two accused persons. Against two persons, dash the present accused and the aforementioned co-accused. Aforementioned co-accused, semicolon, who, as noted above, has been granted bail. Considering the length of detention, the completion of investigation, and the aspect of parity, dash, the present accused is allowed to go on bail of 30,000 with funds saved. The satisfaction of the concerned learned court, subject to the condition that the shall not shall not indulge in illegal activities. Number three, he shall be available for trial, comma, if one commences. Number four, he shall not hamper or tamper with evidence. Violation of the bail conditions and cancellation of the. He cannot be applied in this case because very good case for case 23. Actually, parity per se cannot be applied in any bail matter. Every case is different. So I use the expression aspect of parity. But please point out. No, please point out. I will appreciate. Yeah. That one. But from him, may have been recovered. May have been recovered. May have been recovered. Then, okay, it's good you pointed out actually. That kind of further fine-tune that expression. And including the aspect of. We don't know. So in a way, it's premature by any means. We do have some plus minus flexibility in bail. Aspect of bail granted to the co-accused by this court. It's right like that. You're right. Never hesitate to point out this. Possible. Bail petition stands allowed and disclosed. Possible.
Whole person lordship, they were suspected lordship, they have stated the grounds of LLT. Arrested person were habitual offender and they have revealed that they have habitually committed theft. In the case of theft lordship of the train, coach lordship of train station. Some 2-3 FIs were there lordship, something has been stolen. And the other they were suspected and they had been put behind a bar. And there are 33 days and further no recovery regarding the LS stolen items which have been mentioned in the FIR. So simply on mere own suspicion, they were arrested.
Per se, theft in train at night. This is we all agree.
33 days behind the bar.
We have to see the materials. But Extortion selected. Only on ground of completion of investigation, and we have to grant. We will not call for any report. That can also be one of the options. But as a prosecutor, what do you say? Would it be, you think it will be better to see the diary, the scanned diary, the charge sheet, what has been found instead? Otherwise, let me see the FIR ones. 24/7.
I think that the theft, I think the granted in the finding of Sassid lordship can also grant bail lordship.
Which one?
This lordship, the only allegation of regarding lordship that, tap lordship that habitual, 7 years. No, I'm just reading. FIR lordship has been had 3-4 incident lordship, that such kind of lordship. Valuables were stolen. Valuables. Allegation is quite serious. Big gang. Big gang. They've stolen from Rajdhani Express. Nobody wants sale. So I think, will you, what are the sections under which it has been charged? I don't have position to say that. The section has been, 305C and. Based on tribal sections. No, one is section tribal. In that case, if you. No, that's why I asked. Would you like to approach? Regular session tribal lordship until and unless it is committed lordship. Sessions tribal, if it is not punishable, life. No, then it can. 370. The name of the judgment. Very short. Life is there. Life is there. 370. Life. Lordship. Then it will be. Yeah, habitually receiving lordship and dealing in stolen property. They are not, as per the allegation, they are not receiver lordship. They are theft allegation which against them. Habitually dealing in habitually dealing is slightly different from receiving lordship. It's like trading. Lord. They may be. But anyway, it's very, these are, you I mean, institution is already a novel. So if he is not, something more needs to be seen, I think, in my opinion. Rather than just completion of investigation and detention. So since he's not willing, because of sessions tribal to approach, we'll have to call for the scan copy of cases. Yes, we have to call, do that, so take that option. And next week, what will be possible? If it comes, no problem, or option next, and then it's a minute. The Landed counsel for the this person's name being was stated to have been arrested on 9/8/2025. All are named actually. The Azahar, the FIR has been lodged by a police official of the RPF. Yeah, on 9/8/2025. So the detailed FIR. After arrest lordship, the FIR has been lost. So they all are, after knowing their names and address lordship, they has been incorporated in the FIR, which is they carried out the search. After they have apprehended this FIR on basis of intelligence, crime intelligence.
And emissions. Fire. Has contains detailed allegations about an organized gang found to be involved in theft of passenger belongings in trains, including in Rajdhani Express. Some of the suspected persons have been named. Stop. Learned additional people important for submit that investigation is completed and charge sheet has been submitted. However, considering the serious nature of the allegations, it would be prudent to peruse the scanned CD and CS before disposing of the bail petition. According requisition, the scanned case diary and CS. That case record is not necessary. CS and CD and CS scan. List on. I have no problem about this. If it
18
comes-
lots will be possible.
No, I have no problem. If it
Lots.
comes, it's not-
18 lots.
18 lots, 22.
It already 33 days lot. If if charges have been given in 305.
And we can try on 19.
18 lots will be possible. $18 lots.
I had said 19.
Not
19.
not lot.
You have accepted notice.
First, the respondent side, there is the Washington CRPs. And where the party made yesterday was implement the PP. Unless the commissioner secretary of the home department is.
No, because that is what I thought it was a habeas corpus matter. Because when I looked inside and she also pointed out, it is in substance a Washington.
Yes, washing, but some allegation is that the non-registration affair is a affair. But in that case, the home department must be a party. Otherwise, yes, the characters.
What is your prayer? Let's come to your prayer.
Yes, Your Lordship.
So what is your prayer?
Sir, my prayer is to set aside and pause the influent order dated 16/6 and 28/7 of passed by the learned judicial magistrate in Golaghat CR case 85 of 25 and pause the entire proceeding in the CR case for being illegally arbitrary and in violation of section 223 in subsection 1 of BNSS and pass an order thereby staying the proceeding before the judicial magistrate for Golaghat in the case of Varundeep Singh versus Mandeep Sokela.
It's a 482 petition. It's a quashing petition.
Yes, sir.
Right? 528 BNS petition.
Yes, sir.
Actually, the right state respond is the state represented by public prosecutor, in my opinion. So should we get it re-registered? Criminal petition. The form will change, substance will remain the same. Mr. Bottom, can you not be able to appear?
Maybe converted to.
That again. It's your good name, please.
Skip.
No.
Oh, Rita Sharma.
Your
Your Lordship, have a prayer. While this matter is pending before this honorable court, please, Your Honor, would stay in the lower court proceeding. Please pass an order for stay in the lower court proceeding.
The instant application has been filed under section 227 of the Constitution of India, read with section 528 BNSS 2023. Start. Upon perusing the materials prima facie, including the prayers made in the petition, it is revealed that the petitioners are aggrieved by the proceeding of CR case number 85 of 2025, pending in the court of learned CJ and Clerical, whereby cognizance has been taken and summoning order issued against the petitioners. The case has been registered as a writ petition criminal. Copies were served to the learned government advocate. Good name?
Escape.
SK. Whoever, however, submits that if the matter continues as a writ petition, perhaps the Commissioner and Secretary, Home Department, the Government of Assam has to be implemented. At present, the petitioners have implemented State of Assam, represented by PP as respondent number 1, and informant, right? Varun Singh is the informant, complainant,
Complainant
complainant.
in the CRPs.
Varun Singh, the slash complainant as the respondent number 2. Considering the fact that the proceeding is essentially one invoking the inherent powers under 528 BNSS, the instant proceeding may be converted and re-registered as a criminal petition. How much time will it take for re-registration? That's re-registration. Re-register. Converted into criminal petition.
That was taken city.
Petitioner side file the amended costing. You file the amended costing. Okay. And thereafter you serve copies. And serve copies of the same may be served upon the public prosecutor. And also steps of notice may be taken after you file, then you can. Okay. And it will come up on to this Wednesday, right? So when should we allow it to be? It's a complaint case, right? So we can.
Yes, and let's see, file the first.
You file it. File it. File it. And should we fix it on 15th?
So your lordship, 15th won't be possible. I come from Delhi, and on my dates, I will after 22nd.
22nd.
Yes, your lordship. That is why I am requesting this honorable court for this stay, because I have matters there already fixed such dates.
The petitioner, but I think, don't you think it will be proper to consider the stay and pass any necessary orders after it is converted to a criminal petition, and then, or do you think that will be hyper-technical approach? That converted into a criminal petition and then copy is served to the PP also, and thereafter interim prayer is taken up. That will be better, and you can always appear through video conference. Yeah, that's it. You can appear. No,
So you are saying that on 15th,
no, after this procedure is gone through, that you file the amended petition, it is converted, which means you will get a criminal petition number. For 82 matters are registered as criminal petitions in our High Court. So you get a criminal petition number, and thereafter, public prosecutor would have a copy, and thereafter, I would prefer given a choice.
so meanwhile, you will be giving any stay.
No, not that. I'm not saying about that. The prayer for stay, I would like to take up after this initial steps, which can be done quickly, or within a couple of days. And on that particular day, if you cannot come physically, no problem. You can always appear by this.
Okay, your lordship.
Some local council will be there. Oh, right?
Then she can file first title amendment.
You can file if you have the.
If I file it today only,
You can
then
file
there
it.
is
You can take it up and the conversion is done maybe second half of tomorrow. We can make it. Second half of
If undertaking is given, then that will be fixed.
okay. You are in a hurry since you are going list tomorrow. List it tomorrow. Difficult.
on 15th.
15. That's why we see some time frame. Bit of time. Otherwise, this is not a problem.
So then then the senior counsel will appear.
No, that also too. Good enough. And then on that day, we'll consider the prayer for interim and pass necessary ones, right? But that will be proper. Based on 15/9/2020.
Very good.
After some time, no?
As on today, 60 days behind the balance.
60 days.
60. Earlier 2 times CD was called. Last posted was 8th of.
Well, as per my instruction, just do sometime take official receipt proposal.
And after tomorrow is the holiday. Oh, tomorrow we can pass. Tomorrow we can pass. Then because he's completed the investigation, if not completed, he may be entitled to the tomorrow. Tomorrow. It's about the solution. The learned counsel has pointed out that Mr. Hussein Haris counsel petition, follow petition, points out that the petitioner, the accused has completed 60 days. This is
It is 90 days.
90 days,
90 days.
not amounting to murder. The water learned additional. The case diary has just been received. And pays for fixing another day, either tomorrow or Monday. I'll leave it to you. I'm sorry.
So then 17 or 16.
He has convenience of 16 or 17. 16 or 17. Which one you prefer?
16.
16. 16 now. It's not received. That is not received. What am I doing? Case diary is stated to be not received. Should press reposition. The interim protection granted to the petitioner by the order dated 19/5/2020 shall continue with the next date of this term. Big song. 23 now. Okay.
Lordship, for the time being, Lordship, Mr. Jamon, the senior counsel is on level number 6. Let me allow
Yes.
instruction.
Yes.
Charges in Python.
Case diary also case diary also. They try to get the instruction. Wait for another date. Interim. Case diary not received. Issue remain. Interim order. Interim bail. Interim bail. Granted by the order dated 23/7/25. So continue to the next date of list on. You want it next or day after? 19th. And yeah.
Petitioner number 5. Starting
5 to 10 are on interest. Since there are 10 petitions. So we wait for another. PD not received. Case diary not received. Issue remain. The interim bail granted to petitioner number 5/027/29 to 10. Sorry. 5 to 10. 5/6/7. 5 to 10. Stand extended till the next date of listing. Fixed on. Which one? 23? 23/9. Right.
Only subsidy is filed. In this case, I'm an interim. In the after nothing allegation is basically kidnapping, victim is major, and immediately the relationship is all there, my lord. And I am projecting here, my lord, consenting parties both are, and voluntarily eloped in order to their relationship. So, absolutely. Open to the trial. Finally.
And there's no apprehension, but disposal. Apprehension also. Usual process would be conducted. Require notice to the informant. Okay, but the learned be additional to be some extent. As per wireless communication received from the concerned police station. Upon completion of investigation, final report/closure report will file in the case on 28/8/2025, right? FR number 49/2025. Will be on the same. For apprehension, the apprehension of arrest of the petitioner does not really exist. Nevertheless, the interim bail and granted to the petitioner, one petitioner, right, order dated 21/8/2025. It's hereby made absolute. We have hereby made absolute, that's all. Bail petition stands allowed in this. That may be part of the communication will be kept as part of the.
Made. Pursuant to your lordship's order under dated 21/8/2024, like the petitioner appeared before the. And her statement has been recorded on 23/8/2025. City was proposed.
Yes, there you know, the receipt. This Islam Learned Council. Petitioner submits that pursuant to grant of interim bail This petitioner appeared before the IO and a statement has been recorded. Issue reminder for the is that meanwhile, the interim protection by order dated 21/8 self-stand extended in the next date of this. Fix on. Want to service the. After that issue. Yeah, many. Is there. Yeah. 15 or 16, or 16, 10, 16. But.
Lordship, actually, the case 9 names. This matter of for excellence. For sequence control, even lakes in other book. But he has the not matter up to it. Will be 97 for the most part is matter for this.
Should I keep it for time? Take a chance.
He has done for it.
Okay. Take it. Find out page 12. Let's get the conclusion. Page 12. Is it connected with the other? Because his other petition also 1 crore.
Yes,
amount
that
was
is
there.
very peculiar.
I have not
I have also not able to understand. After doing
At first read, I have not understood,
Yes, madam.
but I'm sure you'll help me to understand.
And actually, what in fact, so far, allegation in the FIR is concerned, madam. Basically, pinpointed to my lord one Manas Patin Sharma and my lord Jury Devi. And petitioner before lordship with my lord Raja Kamarkar, my lord, I am a my lord goldsmith by profession, my lord. And the Jury Devi, my lord, who is the prime accused of this case, my lord, has ordered some gold ornament, my lord, from me, my lord. And to that effect, my lord, she, my lord, transferred an amount of 70,000 in my account, my lord. I have annexed the copy, my lord. My license is at page 9, my lord. Is my lord, my trade license, my lord.
The pair here, the petitioner is Raja Kamarkar.
Raja Kamar. I am a goldsmith, my lord. Page 9 is the my lord, trade license, my lord. It's a type copy. Vernacular is at page 11, my lord. And my lord, we did ordered some gold ornament, my lord, page 25, my lord. It's a my lord, second copy, my lord, sketch, my lord, of his
Page 25.
page 25, my lord. Page 25 is the type copy, my lord, page 26 is vernacular, my lord. The second copy, which I kept, my lord, at the time of my lord, his order, my lord. Here, my lord, name of jury is my lord appearing, and also my lord, her phone number is also appearing. My lord. And page 26, you will also find the design of ornament. My lord. For this, my lord, consignment, my lord, said jury Devi has, my lord, transferred rupees 70,000 in my account, my lord. I have annexed the, my lord, bank statement also, page 27 on March. And so far, my lord, FIR in the election, the FIR is concerned, my lord, I have no knowledge about, my lord, what transaction that has taken place, my lord. It's about, my lord, 1.2 crore, my lord.
Yeah.
Since my lord, lordship, that part my lord, I have also no knowledge. But my lord, 70,000 has been my lord transferred
Retired from Golaghat
Home Guard office, lordship.
ordinarily plus people.
Since my lord,
They
UDB
cannot
has
have
my lord, since
so much money to lend.
that, and that too my lord without any document. Now my lord, since UDB is the my lord prime equity, then see my lord transfer rupees 70,000 in my account, my lord. Now I am apprehending. I'm ready to cooperate my lord all the way, my lord.
Is there any small? Is there any receipt adjustment?
Just with the second part. The white seat, there might have been a particular amount of money by some other this person, they can deposit into the account of the husband. The first part. Second part is that when that money was which unaccounted money that was transferred thereafter, the person who deposited the amount they started calling and saying the CBI officials now looking for it. And now, new phone calls has started coming to them. And introducing himself is a the CBI person started taking this is the case. Now, in this case, filed a conflict. Filed an objection, during the course of investigation, collected materials, various transactions, even from the statement of the that is of the accused petitioner. If another transaction with the appeal that accused when Julie Devi is there, then that may be another part. Apart from that that is the of the transactions from the account of the informant and relatives are there. Police collected those amounts also, particular amount. 41A notice was also sent. Various efforts were made for a long time but not able to break this part. He was requested to come from the
Which person? This
present.
petition.
I'm on that introduced him as a CBA person, collected that money. And he is nexus with that that particular apprehended that is accused person, who also in her statement stated to recover that particular amount of money, these persons along with another, that was also even arrested by police another co-accused person. And this all things are there. So this investigation is progressing by using the name of CBI the money is collected. Obviously, that unaccounted money may be in the course of investigation, maybe prosecution may be drawn against them also. Different fund. But here in this case, in the petition, the present accused petitioner is very much involved. And prime of the evidence are there. The investigation is going on at this stage, they will be provided so far, kindly produce only regarding this present in the accused petitioner. I have back along with the bank statement. Transfer money is concerned, I have also admitted and I have another statement, bank statement of myself, on page 27 on what and since notice has been issued for my appointment, some protection may be given, I will cooperate to the police.
Yeah. Yes, arose out of Eberhard dated 6/4/2024. For the facts that are stated in the FIR are apparently quite complex, but indicate the monetary transactions. And one of the amount being mentioned very as much as rupees 1.2 crores. There's reference to various persons in the FIR, including the present petition. The petitioner counsel submits that the petitioner seeking bail hearing, the goldsmith by profession, he had received some money in this regard for jewelry work from main accused jury Devi. Peruse the relevant documents. The case diary has been received along with a bail objection. The learned additional PP submits that investigation so far has found involvement of the present petitioner along with others in fraudulent in the racket of fraudulent monetary transactions. And objects to the grant of bail, submitting that it might prejudice investigation at this stage. I've gone through the bail objection. The IO has contended that the wider racket involved in this fraudulent activities in which the present petitioner has been found to be directly linked. Upon perusing the statements of some of the witnesses, they find that it has emerged that the present petitioner, along with others, had represented themselves to be officials of the CBI. So, admittedly, the present petitioner is not a CBI official. In the given facts and circumstances, I find force in the contention of the prosecution. Accordingly, the prayer for interim, prayer for 2 years bail stands rejected at this stage. Return back the case. Fine. Right. The investigation carried out. It was the last order dated 11/8/2025. No report has been received from the registry regarding appearance of any new counsel on behalf of the petitioner, who remains unrepresented today also. It is reiterated that registry may kindly verify whether any new set of counsels has appeared and put up an appropriate office list after vacation. So question after vacation. List after vacation on 16/10. 15/10. 15.
Yes. The last occasion, I got on 27/8/2025. This court has passed an order in respect of 714, IA criminal 714, in lieu of IS 643, 2024.
Just a minute, last. I,
Order is all completely correct, but only miscellaneous case number. Oh, there is typical mistake by the private assistant. It should be passed in for correction of age. My prayer was in 643. My prayer was allowed.
IA 643. Criminal Act 59 of 2002.
The order was passed in 714.
Which order? There was a mistake in our order.
No, my lord, no mistake in the order, in only this. IA number. Oh. It was, order is 100% correct. No, it's okay.
So. Which, the age should be 32 years
32 years.
instead of 59 years.
Instead of, it was allowed by this honorable court. Okay. And now what are the penalty? This, instead of 714, it should be 643.
Now, can I see the order? This is sought to be correct. It's post of line.
Oh. Even mere mistake, even error.
IA number has been wrongly.
Yes, it was. Wrongly inserted. Order is correct. Sir.
So the actual number should be
643. Thanks.
In criminal appeal
59.
59, 2025. Error had crept in inside of the petitioner with regard to the age of the appellant petitioner. And that instead of 32 years, it was incorrectly mentioned, written as 59 years. So for the same, IA 714 of 2025 was filed.
64325.
Again, same mistake. And IA was filed for correction of the same, and which was allowed by the order dated 27/8/2002. However, in the said order, the number of the interlocutory application was incorrectly mentioned as IA criminal 71425 instead of IA criminal number 643 of 2022. 645 bold. The applicant seeks correction of the same, which is allowed.
Which was earlier allowed, man. Now, my lord, if your lordship can be entertained is 714. My lord, my prayer in 714 is only limited prayer. My lord, the mother of the petitioner is the age-old lady. And the petitioner will be allowed to grant bail either for a period of 20 days or the convenient as or maybe granted bail, my lord, at this stage.
That petition is not before this honorable court. my lord, the matter is come with criminal appeal 59 of the 2025.
No, that is there. Criminal appeal is there.
640.
In IA 714.
This
This
was
714 is wrongly mentioned. It should have been 643. So actual 714 is not before us. Right? We should be careful, otherwise we mix up things again. Criminal appeal, 59 is there, the main criminal appeal.
and IS 642.
643. 643 was filed for correction of the A's, which was allowed. Yes. But in that 643, instead of 643, it was mentioned as 714 in the heading. In the order it is. Am I right? Now 714 is the one pertaining to bail, right?
Yes, madam.
But that I do not find it.
Because my lord, that is not concept, that's is a cause list, my lord.
That is,
The cause list, my lord, along with the criminal appeal, one, my lord, I is there. And 714 is not before is another one. Today,
one file is there, 714, but it has the order of successful. So, correcting this age. In the cross title of this petition, is find that it is for suspension of sentence. Bail. Have a look, this it can happen sometimes. Just look it up. So that we again don't make again no mistake. Yes, creeps in. If necessary, you can just sit and we'll take up another matter. You can sit and see. Right. Then have a look and then next matter we can take. We'll take it up after something.
Legal lordship. So this is for suspension of sentence lordship. This regard lordship, we have taken steps lordship upon the respondent number 2 lordship. For the registry, as well as for the office of the public prosecutor.
Respond number 2.
Lordship,
Informant,
lordship,
Boxo matter.
lordship.
Sentence to rigorous imprisonment.
7 years. Get the instruction. Let them get the instructions. Lordship.
IA 344, right?
Lordship.
2025. The council submits that steps have been taken on the respond number 2/informant in this application filed seeking suspension of sentence and bail for the convict appellant. Who has been convicted under section 4 of the POCSO Act and sentenced to undergo RI for 7 years, fine of 10,000, ID, RI for 1 year.
Let them take the instructions.
The prosecution, we got to learn additional people. Shall take instructions to the concerned police station about service of notice upon his conduct.
Can we fix on 24 lordship? Oblige.
Please on 24. He's been in custody for how long? Pursuant to his judgment. Just an approximate. Don't remember it's 25 judgment, March judgment, lordship, couple of months, lordship.
Oblige.
Yes.
Yeah, I even substituted sentences, my lord. Earlier, my lord, this shall call for done. Now this is the further reminder.
common judgment.
Yes,
Cases.
madam. Two cases here, madam. 4 applicant on, one is already given with the jail, my lord. The applicant number 3. Women 1, 2, and 4. That is considered after this.
Yes. Not received. I 856.
Yes, madam.
1856. The extent application of bill file for suspension of sentence bail for the convict appellant. Submitted the prosecution that scan TCR has not yet been received. Show fresh requisition. List.
My lord, before the election, my lord, any day.
Fix it, but it comes from.
Sirak,
24.
yes.
Ma'am, please. I is for suspension of the sentence by the.
46.
Yes, 46. There is an IF for suspension of the sentence by conviction is under Wildlife Protection Act, section 51 of the Wildlife Protection. 7 years conviction is given.
Assam amendment now increases it to.
Yes, so there, only the issue, my lord, is not so, only issue was that we had another thing. What should we find the allegation is recovery of some 4 numbers of title, money. Should we find judgment is 17 million. The main crux of the issue is the position, conscious position of the person is not confirmed. For that aspect, your lordship will find is you want evidence of independent witness of PW3 matter that your lordship will find at least 22 months. Page 22. That if he is the only independent witness when the first seizure was taken place.
Witness number
Page 22 month.
of the judgment.
Judgment. It's in the
In your compilation.
affidavit,
Page 24, yes.
22 month. Last part, last. This is Gokul Kolita. PW3 man. He is the independent witness. 22, 23, he says man categorically. He went to the house of Raju Das, but at the time, Raju Das was not available in the house, in his house. And so Raju Das position.
Found from his house.
Yes, my lord, your lordship will find, it's actually, it is not only his house, it is the house of the father brother. He also reside here definitely. In fact, your lordship will find.
Other family members also. there.
Yes, other family. And he has said, my lord, and his wife and mother were present. Raju Das was not there. So position, my lord, position is in doubt. PW4, my lord, who is the, my lord, investigation officer, in fact, police officer, who sees the material. He said Raju Das was there. There is very contradiction on that.
He said that.
Page 12, my lord, para 12 in the same page, my lord, page 23. Rugo Thakuria. In his evidence, they stipulated on so-and-so Jaishagar outpost. This year, receive a secret information about the goods being available in the house of Raju Das, son of Thogen Das. PW4 deposed it on direction of IC. He, along with other police staff, proceed to the house of Thogen Das. Definitely house of Thogen Das. PW4 deposed that he also took some independent witnesses with PW3 man with him and searched the house of Thogen Das. He searched the house of Thogen Das. And in the course of search,
recovery of 4 numbers of turtles of which were in silver colored aluminum box. That is also contradiction in that case also, madam, in where it was kept. While other turtles were found in similar silver colored aluminum, PW could depose that accused Raju Das was available at the house. So first seizure, this is the first seizure. And second seizure, my lord, once the police officer seized these articles, this was again resisted by the second seizure by the forest officer. There also it is contradiction where from it is seized. If your lordship may kindly see the 4 evidence witnesses. The first of all, the conscious position of the petition was not there. The independent witnesses said, madam, I was not there. Other all the investigation officer, the PW1, he said, my lord, if your lordship may kindly see page 21, he said, he said that this seizure, he made this seizure in the office of the, my lord, his office. His office. But PW4, while the IO police officer said he handed over this all these articles in the police station itself. So where from it is seized, the position of the is not confirmed, the seizure is not confirmed. That aspect, the very judgment itself is wrong. So and this is this
Democracy, we are just seeing it actually now.
Yes.
We cannot conduct an appeal hearing.
Yes, yes. This year was confirmed. Then my lord, we have to go through the my lord positions. Already it is called for my lord.
Has it been received?
Not it.
Has it been received?
Otherwise, I have the my lord certified copy of the old my lord the positions. The position is more clear in fact, my lord.
So that, yeah, you are annexed, no doubt.
Yes. All the my lord CR and
You have annexed the judgment.
so I have annexed the judgment.
The questions also here.
The questions I have.
So we wait for the PCR.
It is better, because it is already called for by the honorable court. Otherwise, I have.
Let me have a look. Written actually to receipt of this. How soon can we get it?
My lord, it is from my lord.
6 hours.
Already called for my lord, can be a reminder before my lord vacation. If the lordship may kindly see the first statement, that is of W1, my lord. He said Raju Das along with 4 numbers of turtles were handed over at our office. This is specific. But the other witness, PW2, my lord, he has said.
Remains to be seen at the time of appeal hearing.
Yes, yes.
But
The office is
another factor that we have to see in this suspension sentence matters is that, we should have an idea actually. What is the average time being taken now in the disposal of filing the single bench sentence? Well, we have to see. I'm not saying more or less. I'm not saying, but we should have an idea. Suppose it is 6 months, then the approach should be little different. Suppose it is 3 or 4 years, then the approach should be like different. Because definitely the presumption of innocence is no longer available, but at the same time, a person cannot undergo substantive part of the sentence while his appeal is not yet being heard. That has quite constitutional values. Anyway, so that is fair on his part. Let us, since this was called also by, I consider all these aspects, but we are at the moment, we are not, I don't know actually. Informally, we can ask, we don't know what is the average time our division bench criminal appeal is taking, single bench criminal appeal is taking. Actually, we have an idea. And it is very necessary because it has joined the queue now. It's a 2025 criminal appeal. Now it has joined the queue. How many cases are there in the queue?
My lord, pending since my lord 11, 12, which are
So
Now,
but 11-12 matter, people won't be in custody.
yes,
That'll be very short.
Those were,
Very wrong.
bail is granted or suspended.
So that is, that's also we have to see that aspect, right? So anyway. So when you admit an appeal, if you admit an appeal, rehear an appeal, the both possibilities, the balance of scales might be into this, that side, depending on the infirmities pointed out. Otherwise, in any appeal, both the possibilities are open. Yes, that the conviction, the impugned judgment may be upheld or may not be upheld. If someone is sure at the outset only that it will not be upheld, then it's better not to admit it, which we don't do. Statutory criminal appeal is a right. So these are the complexities. These are the complexities that we face actually. But in any appeal, if bail is granted, one essential condition, in my humble opinion, should be imposed is that he should appear before the trial court once a month, so that he's kept track of. Yes, that condition. But generally. Now, you no need to go saying it's not that. You find learned counsel for the applicant appellant. We shall learn it for proceeding say prospects. So in his preliminary submissions, the learned counsel, the applicant has tried to point out some alleged infirmities in the impugned judgment. Thereby contending that it imparts a reasonable merit to his criminal appeal. The scanned TCR was called for, but not yet received. Issue press requisition / reminder for the same. List. You can suggest. You can take a chance.
Yes.
We need to. Register. Yeah, it will be through register. Can you take this up? Yes, yours. More clear?
I have come through it, madam. Madam, my submission, what I am stating is that, madam, today is the causalist method. That is the criminal appeal. The case listed before your lordship is that high criminal 640/2020. This case is relating to the age, madam.
Which is done.
Related to the age.
Which is done.
Order is passed, madam, but my lord, not in this case.
Yeah.
However, maybe rightly wrong, an order was passed, my lord, but that was passed in my lord. Item number 7-1, my lord, that is your this high criminal, my lord, 7-1/4/2025. Wrongly, my lord, that order was passed high criminal 7-1/4/2025. And my lord, thereby that, my lord, that was disposed of, my lord, accordingly. Whereas 7-1/4/2025
Was for suspension of sentence.
petition for suspension.
That
of
should have
sentence.
come today. Actually,
So,
the
my
order
lord,
I dictated today, can
Yes.
it be in this fight?
Yes,
No,
my
it
lord.
cannot.
So but my understanding is that, my lord, today, my lord, yes, because the case before us is high criminal 640/2025, where recording that, my lord, wrongly, my lord, order was passed on that fight. That is to be, my lord, passed, and that may be disposed of. And accordingly, as because, my lord, that is the suspension of sentence. Wrongly order was passed on that matter. That was disposed of. That may be, my lord, again, my lord, you could recall that order. Otherwise, then only, my lord, that may be listed.
And then it
But
will-
only we can, my lord, please to pass an order regarding that suspension. Because that order was passed, my lord, that.
So it has, we'll have
Yes, my lord.
directed to be listed with the
These
actual
7
643.
And my lord, that is to be earlier, and that is to be reflected in the order. All right. Yes.
I have no objection with that. Another date will be necessary.
Yes, because my lord, otherwise, where my lord, the order will be passed, because that was disposed of, my lord. Maybe in a different order, but that is not before.
We'll have to do some corrective surgery.
Yes.
Right. Which are the important. Should we give a date for this, for listing it properly? Yes.
My lord, before today, it may be.
This can be, not wait till after vacation. Next,
Or
next.
otherwise, my lord, in this case, my lord, PCR also received. You already. If
So-
my lord go for the hearing along with that, that can also be done. Because my lord, very much.
TCR, the appeal.
Yes,
Yes,
my lord, because my lord, the PCR, my lord, is available, and my lord, that is, here, my lord, that is sentence is
4 years.
4 years. 4 years, and the my lord, judgment dated, my lord, that is, judgment dated 26/12/2024.
My lord, it will be,
Or my lord, may, here, my lord, is suspension.
suspension. No, if we hear, then probably, I don't know, you subject to what you suggest. Maybe better to, try hearing for the motion day, because hearing matters. Others are in the queue.
Yes.
Others are in the queue.
So
They
this
also have-
suspension matters
Everyone is
maybe
waiting.
hard,
Yes, yes.
Maybe take it fast. So you're right, actually better to dispose of, hear the criminal appeal. Better to, yeah.
24, my
So
lord,
let it come then, come on, 60.
as per your lordship.
70. Yes, sir. Let it come on 70.
One of them is order. My lord.
I'll have to correct,
Yes,
rectify.
yes.
I'll rectify it.
My mistake. God bless.
Or interim order.
My name is before I came to know about the matter, only one of my juniors called me this afternoon while I was attending cases in the courts. Therefore, I do not even have the file. And they have not given me a copy of the law. Although I entered the parents, they filed lies as well. It's a matter pertaining to company fraud, bank fraud, and number of other frauds, fraud upon the court also. They played a fraud upon the court based on those, they have got some state. And what I was waiting for,
You are the informant,
I'm the complainant, yes.
complaining.
The informant, the complainant, the respondent. And most importantly, there were matters going on in DRT, which have been resolved. So we have got most of our evidence and we'll be filing those shortly. We are just waiting for a few more documents that we have applied for certified copies. And once those come, we'll be going for final hearing of the systems. In one case, they put the interim order, when I was away from Guwahati, when my mother-in-law passed away. That was the time there was a ceremony, funeral ceremony, of the ceremonies going on, the interim, those days.
Family members.
Yes, my mother and my brother.
My lord, my respected friend is. the
Sometimes it
doctor-
can happen.
My lord, so my lord, this is purely a company dispute, my lord, going on. And for that, my lord, my lordship is well aware, my lord, that the company tribunal is there. And this, my lord, cases can be adjudicated therein, my lord, on that is one of the, my lord, main cause of action of the, my lord, challenging. The, my lord, criminal complaint which is pending before the honorable learned trial court below, my lord. Now, my lord, what has happened, not
But
only this.
NCLT, about insolvency and bankruptcy.
My lord, other issues are also there, my lord, which we have quoted.
Criminal jurisdiction doesn't have.
My lord.
Civil jurisdiction.
No, my lord, that is correct. But my lord, if my respected friend allows me to submit, my lord, what has happened, my lord? Altogether, 4 numbers of complaint have been lodged before the learned trial court below, my lord. And in those, all these complaints have been assailed before my lordship, my lord, before this honorable court, my lord. And this honorable court has allowed, my lord, the interim protection by staying the, my lord, further proceeding of those cases, my lord. So, my lord, on the other hand, my lord, as these cases, my lord, is also being adjudicated by my lordships, my lord, 2 parallel proceedings are now concurrently running, my lord, before the trial court as well as before my lordships also, my lord. So therefore, my lord, we are humbly praying through this IA, my lord, that till the issue is decided by my lordships in this criminal petition, that whether the complaint is maintainable or not, my lord, we are praying for an stay of the, my lord, criminal complaint proceeding before the trial court below.
And my lord, we have categorically stated in paragraph 5 that what is the exact position is about, my lord. That page paragraph 5 of my IA, my lord. My IA number 906 of 2020.
But today you are not ready to, because your name is.
Yes, we'll need another day.
My lord,
because I've not served the document.
another unfortunate event, my lord, by my lord.
Let me get just introduced.
Right.
2 minutes. Definitely you'll get your time.
My lord.
Yeah, what you are saying?
My lord, my submission is that, my lord, altogether 4 numbers of criminal complaint have been filed, my lord. I have stated in para 5, my lord.
Of the
Para
IA.
5 of my IA, my lord, that the petitioner most respectfully states that the complaint and has filed several complaint cases against the petitioner, wherein in this honorable court, another two criminal petition, namely criminal petition number so and so, are pending, and wherein the honorable court has passed an interim order dated so and so, protecting the rights of the petitioner, thereby staying the proceeding of complaint case number so and so and so and so respectively. So, my lord, we are, my lord, by this, my lord, IA, my lord, as these issues are connected before the learned trial court below as well as here also, my lord. So we are praying that, my lord, till the, my lord, this honorable court decides the maintainability as well as the other issues involved in the complaint. My lord, till then, the proceeding at the trial court below may kindly be kept in abeyance. My lord. That is the limited prayer made in the IM. Otherwise, my lord, what is
In this
because
petition, you are seeking quashing of complaints.
complaint, yes,
6672.
6672. Is that annexure 1, my lord? My lord, we tried to search copy of the IA also to my respected friend, my lord. My colleague has informed me, my lord, that that has been declined to be acknowledged, my lord.
That's it, yeah. Number one, they have committed a big fraud of complaint while I was away in mother country. I went all the way to the division bench here, trying to repay those loans. Upon my return to the country. And the division bench said, because the bank had filed cases on me to recover the loans and things like that. But even then, the division bench was not sure how to go about the whole thing because fraud was involved. And they said, go back to the trial court, get all the things sorted out. Thereupon, I went to the trial court as per the Companies Act itself. So the NCLT is designed in a way to handle one side the IPS cases, the bankruptcy cases, and another side is civil part of company. All the criminal part is very well mentioned would go under CRPC previously and now BNSS.
Conventional criminal courts.
It's criminal courts. Not only that, I went all the way again to the division bench and I made sure that notification, which was not issued by the central government, was issued. So I made sure that the notifications are in place for both the CZM score as well as the session score, depending on the amount of sentence. So I went all the way to those states because they have granted 2 stays. One when was away he was criminal, another one when I didn't even come to the just practicing in the trial courts those days after going from abroad. So what I have noticed here is that process and procedure is not in place, which we are trying to build up. Nonetheless, his cases, the ones that he's referring to, are bank fraud cases. Now, those bank fraud cases were going on in DRT. And I have also filed another writ petition now against one of the banks in which my property is mortgaged, which my signatures were falsified. So there are a lot of materials and evidence against them, and already Supreme Court have decided that this is against them. So in the meantime, we're just trying to find a way of staying. This is actually not going to let them anywhere. Reason being, I'm closing it. There's a time when all the 4 or 5 cases will be decided together, one platform together, because there is a substantial question of law as to how are we going to adjudicate crimes committed under the cover of companies. So companies is an artificial person. Companies cannot go and commit a crime. It's always the people will do. So that is a substantial question. Hence, no statements should be granted. Anyways, I've made in compared appearance these cases, and we should be soon going up for additional evidence, filing of the additional evidence, then for finding. That's my humble submission to the motion.
These are the arguments on stay, on the question of stay, or you need.
No, my lord,
I need another date.
my lord, as my learned friend is handicapped today without the brief, my lord, so I don't want that she should cause any prejudice to her, my lord. That's all. So can be fixed on next week, any date, my lord, for the stay, we are praying, my lord, the IA we have filed. My lord can decide, my lord.
Wow. So I
Yes, sir.
need to file the evidence. So I should be given a time.
You want to file a reply?
To this IA.
Yes. That you can,
Because I have sufficient materials, so I'll do the petition.
you have a right to file. So,
But only, my lord, our problem is that, my lord, this family is a lawyer's family, my lord. The mother, daughter and brother is in tussle, my lord, company tussle. I should not utter those words, my lord. But the learned trial court below is also, my lord, is now, as there is no stay. So situation is as such that we may have to, my lord, face the consequences, my lord.
that is understandable, but for a limited time, I think.
My lord.
These petitions.
Yes, my lord, immediately after the vacation, my lord can fix them. My friend is filing a reply.
Hearing for the applicant petitioner, who in this interlocutory application is seeking stay of further proceedings in CR case number 6672
My lord.
2022. Pending before the Court of Learned, JMFC. The respondent number 2 is the complainant. And the bank, Union Bank of India, pro forma respondent. The respondent number 1 / complainant appears in person. And make some preliminary submissions. It is also submitted that the respondent would like to file a reply. So which some time may be given. The learned counsel for the applicant fairly agrees to the same. The complainant may file or affidavit. This is the matter. You can suggest a date.
You know, 10th of October is the, my lord, next date of the trial court below, my lord. That's another difference.
10th of October.
The court is transferred anyways. Therefore, we doubt that 10th of October would be a very tenable.
By the time you,
Yes,
my
the
thing will come, but still. How about 17th? So 17th.
Not 17, slightly.
Around 18th.
Holidays.
It's 18. It is Saturday.
Because again, we have holidays.
Yes,
19, 20.
it's Saturday. Anytime after that.
Yeah. Next reopening day is 22nd.
Fine.
Is it okay?
Fine,
22nd of
22nd.
And disputes can take place within the family. It's not a end of the
Can
matter.
be, will not
It can
resolve
happen. Educated
amicably
families,
also.
a bit rich families. You know, there's all
They are-
big houses, industrial group, they have
Fine.
houses, but
They are
it's always,
egoistical.
it has to be
There's a-
settled out.
There's an element of greed and ego and so. So there's hardly a scope.
Say,
of,
No, but these are the
settlement.
things.
Yeah.
which
I'm an
we would-
outsider, so I.
These are the
but-
things we should not.
But
will not-
whatever can be, you know, family, any kind of family disputes,
Fine.
if something can be settled through the mode of ADR,
Fine.
it should always be resorted.
My lord, even I as a council may have tried to.
But
amicably.
sometimes there are disputes which cannot be settled in ADR. They are genuine legal disputes, which
Fine.
will need a formal execution.
Like I have to repay 7 crores of loan that I've never taken. And my property is mortgaged. My house might be taken away.
This will come,
foreclosed.
this will come, my lord, on the course of hearing. my
It
lord.
makes him,
Fine.
it makes my learned colleague nervous, and I really respect him.
No, I have
But
big
I'd
respect for him.
rather have him on this side than anybody else. Much
Right.
of this.
Right.
Well, I'm sorry, I was able to on time, my lord, because I have a partner matter, well, I'm sorry.
No. It can be different courts at the same time.
My lord. My lord, I am in interim bail and my statement has been recorded. Probably that statement will allow me to case die to be done.
You heard this matter now. Yes.
Yes, ma'am. We heard this matter on the point of my lord. Yes, earlier you also heard it. Page 14 is the FIR. My lord, here, my lord, I'm giving the background of the case, my lord. Petitioner, there are 2 petitioners, they are the tenant of the, my lord, complainant. Now, landlord lost this complaint. The lordship will find at page 14, my lord.
Just a minute. Okay, which page number?
Page 14, man. This is the FIR. The CD was called for probably CD is available. CD is.
Yeah, I remember.
My lord. So even my lord, if your lordship go by the FIR, my lord, your lordship kindly see here, my lord, cause of action shows in my lord 2022. But it was lost on 2025, my lord. And my lord, yes, your lordship kindly see the whole crux of the matter, my lord. Is the last portion of the FIR, my lord. Page 14, my lord. Recently, the GST department also inquired about the whole thing is, my lord, when he was caught by the GST, then my lord, the whole drama started, my lord. So now landlord, my lord, try to remove me from my lord, their tenanted premises, my lord. Lots of cases they are filing, my lord. They are been a complaint against the municipality, my lord, and also cancellation my license, my lord, regarding my tenants, because these are all both, my lord, the landlord and tenant are both from Jorhat, my lord, they are businessmen, my lord. So your lordship kindly see my tenancy agreement, it is annexus 3 at page 17, my lord.
Tenancy agreement.
Yes, that is tenancy agreement in 2016, agreement of tenancy, that is, my lord, 1st day of August 2016, and that the landlord is Nanda Kishore, and your lordship kindly see. See Rajesh Kumar Agarwal. Rajesh Kumar Agarwal is the here, my lord, he is the complainant. He is the person who filed the FIR, my lord.
He is the complainant.
So since 2024, we deposited the rent in Pilot Bank, and court Pilot debt, and everything I have annexed. Now your lordship kindly see what is the amount they have mentioned in the Pilot FIR? It is 47 lakhs. Now your lordship kindly, my lord, see the annexure 5 page 35, my lord. That is the, my lord, legal notice issued to me prior to Pilot filing of this FIR. The exactly same amount they are claiming for me as they are entitled to get as a rent. Page 35, my lord. May I read it? Yes. Under the instruction of my client, Sri Rajesh Kumar Agarwal, son of Sunday Swain, that my client is the owner of the house, building number 7. That you are entered in the you are entered in the possess of 4 numbers of room to client front of the Theory House. Although initially you possess 2 rooms, room from the rent and then it is 7,000 rupees per month, but later on it increased, and thereafter the 2 numbers of rooms were passed by you, therefore they are up to 15,000. And for in the spite of several order or oral notice, as a part of the client, you have to pay NS amount of rent of 50,000. That you have outstanding engaged amount of which is 7 lakhs. 178 rupees 14 lakhs. You to my client, in spite of the many requests, you are not paying the up to the rent, but from the reliable information, my client within the knowledge of my that you paid and deposited just minimum amount that court is not sufficient to fill up the requirement of the outstanding engaged amount. That thereafter my client is not willing to receive any said amount against the used outstanding balance amount of the rent. That it is the mention here that you are fully possess the said mention room without execution any rent agreement in spite of many requests my client, and without having any proper authentication valid documents. You are running your business and did not be mentioned that there is you have to trying to obtain trade license without having any proper valid documents, specifically without executing any agreement, which very much mandatory and prohibited also. So that once your business premises is entered in GST authority, is also you also kindly see, madam, that and the purpose on the part of the client knowledge information submitted to you. I have huge amount of balance amount of GST, and later on this client is well known that inform you that you have applied for the trade license before the Jorhat municipal without having any proper and valid document. Lastly, I don't do hereby instruct you to immediately vacate the associate enterprise without any delay within the period of 90 days to pay the remaining outstanding years balance amount of rupees 47 lakhs 178 7 lakhs 327. So that is the legal notice they were issued, madam. Your lordship kindly since 2016 and 2023, madam, we have taking loan from him and he paid the money. There's a business transaction, my lord, mitigating monetary transaction between them, my lord. It is correct, my lord. I have my balance sheet and my lord, my all the bank statement also annexed here before your lordship, my lord. Earlier in the petition, earlier in my bill petition, slightly there is a mistake in the part of the my lord, one parameter that is rectified in my petition application. I have 5, my lord. Now your lordship kindly see, after getting the interim bail from this honorable court, they went to one of the petitioner went to appear before the court, my lord. When he appeared, my lord, then immediately another FIR was lost, man, by the same complainant. And immediately one of the, my lord, petitioner was arrested, but subsequently he was next day he was granted bail by the Thane court. So, my lord, your lordship kindly see that landlord, my lord, this other city, my lord. Even, my lord, if your lordship, my lord, gone to the FIR, my lord, even any reasonable man can presume that this is a FIR lost by the, my lord, only on purely on, my lord, concocted story, my lord. So my statement has been recorded. Already I appeared. Statement is probably ready along with the my lord case.
I want to go back to the Azahar again. Just give me 2 minutes. Smile. rental dispute and then
My lord,
this,
my lord,
the backdrop of this,
yes, my lord. Your
this
lordship kindly,
FIR came to be filed.
my lord. And also, my lord, your lordship kindly, their advocate notice, my lord.
Technical notice I've seen.
So, my lord, my statement has been recorded. Probably in the statement of what I have stated, my lord, that is there. Right, property, the investigation, my lord, everything, my lord, your lordship, my lord, my custody different thing, all of it. I'm just only voting on it. What the people is there, like,
During protection, during investigation, something. Regarding the conduct of the This is the charge sheet you are referring to. No, this is regarding the case during pendency of the case. The present accused person threatened the.
No, my lord, against that, we also filed a lodge and FIR, my lord. That is a false FIR they have filed. We have lodged, my lord. If required, I'll bring it in the record. My lord, they are going to such an extent, your lordship kindly see, I'll first, they, my lord, they, my lord, lodge and complaint against my municipality for cancelling my late license. I came before this honorable court and this honorable court passed the order and accordingly, my lord. My lord, regarding my case, still they have had, but what, my lord, what about, my lord, what about the complainant, my lord? Complainant, he's also, my lord, he's a sitting cases, my lord, he's been getting bail by this honorable court, but probably my land is appearing in that case, my lord. This is the case, my lord. No, my lord, what they have stated in, but why they have not stated, being that my fire which was lost by us, my lord? Regarding that false case, my lord? That should not be, my lord, bias for that should be, my lord, fair, my lord.
Everything should be placed
Yes.
for the court anyway. So this is the, you're drawing my attention to the bail objection. Initially. Since not bail objection to whatever the during the investigation that while during inmate protection, the petitioner has witnessed the present bail information regarding that, he has lost this file with the concerned police station regarding that aspect. The statement of the wife of the petitioner is available. So these are the things when the petitioner has contained during his investigation, he will put it down regarding other. That's why I think might be. Would you like to submit? No. I like no submissions, but I think
my lord, that was pointed before the my lord learned court below also, that is taken into account of file containing my lord. That second case they have filed, my lord, was granted bail by bail to us, my lord. My lord, I am submitting, my lord, in that before my start my learned friend, my lord. Because the FIR, my lord, they just to try to, your lordship kindly see the modus operandi of the my lord person, the complainant. When I'm granting interim bail, I went to the my lord, lodge my record my statement. Then immediately the my lord filed another FIR, and one of the petitioner was been arrested. And that case, my lord, then when I got again bail here, my lord, there, my lord, another complaint they have filed, my lord, so that my lord, my bail can be cancelled. But in that aspect, my lord, I also filed an FIR, which was my lord, GPNT was made. That is, my lord, your lordship kindly take into account, my lord. That is not been placed along with the case there, my lord. But that means police has taken aside, my lord. Because similarly, I also filed a FIR. And that is the observation, my lord, by the when granting bail by the land court below. In the other person, who was arrested. This is the order, man.
Copy of this, we'll keep a copy of this, right? Then this is the original. So let me take his submissions. Also, I think if we close the arguments today. Yes, so I think I will take only few minutes. Because I don't think be more comfortable to dictate later. Not sure. So I'll have to study the file.
Yes. Well, my,
Carefully, because there are a lot of
yes, yes. Well, my case is very simple.
It's safer.
Yes, my case is very, this is an old person, my lord. And he's living by renting some homes. Now, from 2007 onwards, these two persons were the tenants. No dispute on, and accordingly, there is some relationship as well. And there's some dispute also arises in between. Taking some advantage of the fact that they are good relation at the time. One day he has taken me to a hotel room, and I have been trapped there. So basically, so when I have been fall prey to their conspiracy, manner, and they started threatening me that there's a pen drive containing your photograph, illicit kind of a photograph, and you have to pay me. That's it. Then they started threatening me, and that's an extortion start. So this is a purely case of an extortion from the landlord. And now, Lordship, they are saying that this is a false FIR because of the. Well, kindly consider one thing. In my FIR, I have categorically stated that I have been certain I have been extorted money because of my some kind of relationship with. So rather I am exposing myself in this particular FIR that there is something had happened and they have taken advantage of whatever had happened. So now they are saying that this is a falsehood. Can anybody, by calling himself, it could be that kind of a trap, Mother? Because I have a family. So now, at that relevant point of time, because of my daughter's upcoming marriage, I could not lodge any FIR because of the social stigma, which is apparent at that relevant point of time. But they are extorting money. Now, Lordship knows, my lord, in the jurisprudence, the person who claims equity, my lord, he must come with a clean hand. That's the law. Now, Lordship, can we see in the last occasion what happened? They are first rejoinder to the petition, the first affidavit, this second affidavit, page 54 to 58 onwards. Their categorical statement that the amount of money they have received from me, it has been returned rather. They have said they have given a loan to me and it has returned to me. That's very specific. They're on their second statement. In the first additional affidavit, my lord, page 38 to 42, my lord. It start, my lord, dated, my lord, 7/7/25. The first affidavit, what they have paragraph 4. That's very important. First affidavit. Right? First affidavit, it starts from page 30, 37. It was filed on, my lord, 7/7/25. And just find it. Page 37. Yes, it starts from 37 and the relevant portion, page 40. Now, paragraph 4. Now, Lordship, can we see what is their statement? Just. Now, for this particular statement, there should have been a case from this code itself for making a false statement under oath. Paragraph 4. That the deponent, that is the petitioner, my lord, most respectfully submit that the allegation that the petitioner made the informant bound to pay an amount of 47 lakh only totally false and concocted, as the real fact is that the said amount of rupees 47 so and so was taken as an unsecured loan by the petitioner from the informant for the business purpose. So they have admitted that they have taken a loan. Now, their standard stand is that the amount which I have paid to them, which I said it's an extortion amount, they said it's an unsecured loan I have given to them. If it is an unsecured loan, there must be some document. There must be some document, at least an agreement to that extent. Whether there is any agreement to that extent, my lord, that I have given the unsecured loan, whether they have shown it in their tax file that this is 47.
That is shown by.
So
Next slide.
from that now, the same has been reflected. Now, this is important in the balance sheet of the petitioner from the year 2022 to 23 under the head unsecured loan, and the petitioner have been making payment of the informant of the said loan in various installments from their bank to the account of the Central Bank India Friendship Jorhat branch. Paid by the petitioner towards the unsecured loan, rupees informant as follows. Now they say they have returned the amount to me on these particular dates. It is their case that they have returned me on the, now on the last occasion, my lord, I have placed my bank statement before your lordship. Lordship will kindly remember. In the bank statement, rather, it is contrary. The bank statement rather shows that these has been rather credited to their account. My bank statement, I have annexed, my lord. They have also annexed.
Credited to their account.
Yes, my lord. It is an absolutely false statement that they have paid me back. Lordship, kindly see once again, my lord.
Yeah.
Our objection, my lord. Lordship will find.
We have not received any objection, man. We have not received any objection. We have not received any.
Copy has been supplied, my lord. 893 on the last petition.
Objection? So
I
has been disposed of, my lord. It is
Yes,
only for
dispose of that is part of the record, my lord. Part of the
dispose
record.
of that is, my lord, only for the purpose of, my lord, implement.
Yes, in that implement, I have annexed that. That I am showing
That,
it's a
my lord,
part of
already
the
disposed.
record.
No, my lord, that is already disposed of. That cannot
So
be, my
what?
lord, again.
So
That
what?
cannot be, my lord. Then I have to reply giving on that, my lord. But
So
that is
what?
disposed
The
of, my lord.
last
No,
occasion for the purpose of my lord.
no,
this
that is
on
for
record.
improvement petition. That is been disposed of, my lord.
So what?
That
my
is
lord?
not the law, my lord.
Why?
The law
Why?
is that, my lord, when there is
No.
that is, my
My
lord,
lord,
they have,
that is the part of the record. Let it be disposed of. The disposal file also can be looked into. It is the,
that, my lord, I am getting,
as per the order,
No, my lord, in dispose of case, I
Let
cannot
me
take
complete,
reply.
Mr. Mohanto, let me complete. You get your chance.
Sorry, pointed out.
Let me point out that when
just
the
give me the-
comes, let me complete. The last order also reflect that is a part of the record. Lordship, kindly see the last order, that will be a part of the record.
In the eye.
Yes, ma'am. It's a part of the record that has been reflected. And I have argued on the point of that particular statement.
Was I 893?
Yes, ma'am.
So,
Written objection has been filed, so accepted in the.
is the written objection you have filed?
Yes, written objection already been filed and has been accepted into the record.
This must be the one.
Yes, yes, that is the one.
Along with annexers.
Along with annexes. Annexes. Okay. So, this is a matter of record, my lord. It has also been maybe seized, well, I don't know, maybe in the case diary also. It is in the case diary probably. My landed. So it is a part of the case diary. Then it's not, it's a part of the case diary. So lordship can take up this. If they are agreed by that, lordship can go for from the case diary itself. Now, from the page 44 onwards, my lord, the amount, my lord, that has been RTGS, my lord, paid by me, page 44, my lord, the from the bottom, my lord, date 18/4/22, then 18/4/2022, then 7/5/2022. This amount has been credited to RD Trading, my lord. They are the owner of the RD Trading, my lord. And the fourth amount they have received is 7 lakhs, that is in page 51. So the bank account, bank statement, my bank statement shows, my lord. This is my bank state, starts from page 41. And my bank state shows that the amount, what they have said that they have paid back to me, rather, it is contrary. Rather, they have received as amount. So they have made a false statement. Now, when on the last occasion, my lord, I have pointed out the false statement made on affidavit, my lord, by them, what they did, my lord, they have admitted to that. Now, lordship kindly see the second affidavit, because now when I have pointed out to the court, so they have become wise now, how they will counter to that.
So let's see the second affidavit.
Now, what they did, my lord, in the second affidavit, it starts from page 54 to 58, my lord. Their second affidavit. This second affidavit they have filed after the last hearing, my lord, when I have pointed out. Lordship can see the dates. Has your lordship got it, my lord?
Page number?
Page starts from, my lord, it is 53.
No, I found.
Yes.
I'm on the second affidavit.
Yes. Then lordship calmly come to page 56, paragraph 3. Paragraph 3. Now, when I have last occasion, when I have pointed out that the false statement they have made, now what they have, this is, my lord, kindly see the last paragraph, last one from the bottom, my lord, 9th line.
Okay.
It is stated in the additional affidavit filed by the petitioner, it has been stated that 43 lakhs has been returned to the informant is not intentional, but mistake committed by the council. It is to the council, my lord. And these council are appearing, my lord. The petitioner himself blamed the council for the mistake. And he is on the, who has sworn the affidavit, my lord? He himself has sworn the affidavit that the money has been returned. When I have argued, when I have shown it that it's a false statement, he has blamed their own counsel that it's a mistake by the counsel. To misunderstanding of the time of drafting. This is the conduct. So it is apparent, they have admitted that the money which they have received, it's not been repaid. So they made a false statement and they have taken the interim. Now, the second part, what happened, my lord? The legal notice. This is a, my lord, what happened, my lord? The lawyer is not appointed by me. The lawyer, subsequently, what he did, my lord, when they got the interim, this particular lawyer, he went to the police station to take the bail. This particular lawyer. It will be in the case diary. The lawyer who has issued the notice on my behalf, he went to the police station, made a statement in the media regarding that his client has got bail. This particular lawyer on media. And he went to the police station to take the interim bail on behalf of these two persons now. And he appeared, he also made a statement in the public. So my specific case is that this notice, I've never instructed to issue a notice to this lawyer because it can't be, my lord. When I have filed an FIR, my lord, against those two persons, that this is an extortion money, where is the question of returning the rent? There is no question. And they have admitted that this is, and this is does not tally, my lord, because they are saying that this is a loan. They are not saying that this is a rent has been accumulated during this period, the 47 lakhs. This is not their case. Their case is totally different. Their case is that this is the loan I have given and they have returned it to me, unsecured loan. And now they are saying this is the rent. I have demanded rent from them. It can't go together, my lord. Absurd proposition. So it is apparent from the face of the record, they have manipulated everything, man. They have manipulated, they have made a false statement to secure the interim bail by making a false statement before this court. So while making a false statement before this court, they have returned the money that they had, that the notice was issued by my lawyer. So on the basis of they have returned it, and thereafter their conduct is there. Also knows, my lord, in the anticipatory bail, the criminal antecedents is very much important in the anticipatory bail. My learned public prosecutors has already pointed out there are 2-3 cases are already been charged against them, and during the interim, their conduct that they have threatened me, and definitely when they will threaten me, definitely I will lodge a case, my lord. Definitely I will lodge a case. It is up to the police to investigate or arrest or not. They cannot say this is a false and concocted FIR. That will be investigated during. And it is not me that I have arrested, my lord. It is the police they have arrested. Must be on the basis of some material on record. So they have violated the interim condition, ma'am. Whether this person is entitled for benefit of the absolute bail in this case, my lord, who has made a false statement on the face of the record, and subsequently when we have pointed out that this is a false statement, and they have rectified, blaming the council. Blaming the council. I would have never been appeared this kind of petitioners, my lord. I would have thrown it back to this who has blamed me for falsely drafting the petition, my lord. And why they have done it? Because it was pointed out, apparently, that this is wrong statement from the bank statement itself. And the bank statement already been on record at the case diary. So, on the basis of this wrong statement, the wrong petition, my lord, mistaken facts, and they have also annexed, and the annexure they have made in their account, my lord. Lordship, kindly see the And not to that, my lord, you kindly see the annexure they have appended in their petition. Not they have only stated in the paragraph, my lord, they have paid me. They have also annexed this particular bank statement, their own bank statement. The misguiding report that they have paid me. It page 46 of this petition, my lord. Actually, this amount has been credited to their own account by me. And they have shown it that it was rather, they have credited to my account. And that they have admitted that fact. No dispute that they have admitted this is, they have not paid it to me, rather they have received it. So this is the factual background of it. This isn't purely an extortion of an old man, my lord, taking the advantage of that particular scenario. He was under the fix at the time. The marriage was on forthcoming. He could not go to anywhere, and he has paid it in some installment, time to time, because of their threatening. That will reveal in the case file. So that's my own submission, my lord. They are not entitled because of the fraud, my lord. Fraud committed to the court, my lord. Not to only to the respondent, my lord. It's a fraud committed to the administration of justice, my lord. Absolutely administration of justice, my lord. If maybe making a false document, making a false statement while in the anticipatory bail, and when it was not, they have rectified earlier, my lord. When I have pointed out, then they have rectified it. That means what? So that's all, my lord. That's my submission. I'll leave it to your lordship on that. I'll take leave, my lord. How much?
So, in my affidavit, I have actually, my lord, I'm late entry in the time of motion, my lord, I was not there. And in fact, my lord, in the time of my lord, having this petition, my lord, that was pointed out. It was pointed out, my lord. That bank account, my lord, that is, your lordship kindly see the order dated, my lord, 15/3/24. Sorry, 10/7/25. So I was not there, my lord, and probably saying behalf of the complainant, someone is appearing, and he has pointed out, and he has dated that on that point when it came to know. It is not that, my lord, afterward it was well done, my lord. Because on that very day, my lord, because it was a mistake committed by the drafting council, my lord, and he admitted, my lord, because of he thinking just reverse. My lord, here I have annexed everything before in my additional affidavit. From 2017, 18, 19, we have a monetary transaction with him, my lord. In fact, in that loan account, my lord, in clearly shown in my lord, I'll come to my, I'll place this one, come to my lord. Everything I have shown in my lord, my income tax return, in my balance sheet. Your lordship kindly see, and now, my lord, regarding their, my lord, the advocate notice, my lord, they denied it, my lord. Then if I denied, why they have not filed a case against him? If he has not been instructed, why he was issuing that, my lord? Till today, nothing has been done, my lord. Now, very beginning, my lord, your lordship kindly see page 103, my lord. 103. That is my balance sheet, my lord. Since 2019, my lord. All these things are happening, they are alleged to be happening in 2023. Prior to that, your lordship kindly. 2019, 103, Rajesh Kumar Agarwala, unsecured loan. So that is his, my lord, I am not going to disclose this, my lord, that is known to whom, my lord. And that is unsecured lien of 14 lakhs, my lord. There is another one, 2019, my lord. Page 103, my lord. Clearly showed in my balance sheet, my lord. That is by the CS chartered accountant, my lord, not by me. Then again, my lord, page 104. That is 1/10/2019, my lord. That is, my lord, shop rent 84,000 per year. That is means shown in my balance sheet, my lord. Again, 2020. Your lordship kindly seen balance sheet, my lord. 84,000 shop rent. Everything, my lord, on clear, my lord. Your lordship kindly is in 2020. Now, my lord, in 2023, my lord. Why they are waiting for so many years? 3 years they are waiting. If it is done in the, my lord, 2020, alleged occurrence took place in 2023, my lord. Why they are waiting for 2025, my lord? Just everything, my lord, has been, my lord, wrapped up because of the GST. Because that has a huge amount. I have shown in my affidavit that it is outstanding. And where from it? When GST caught him, my lord, that is reflected in the FIR also, my lord. In the FIR, they have stated. Now, my lord, GST also, my lord, taking that, my lord. My lord, I have returned 5 lakhs of rupees. That is, my lord, my bank statement is there. That is clearly stated in 101. Now, my lord, I have stated bank statement, I have annexed, my lord. $101, my lord, that 5 lakhs, my lord. That is 16/5/2023, my lord. So, my lord, these are, they are, my lord,
101,
my lord,
page 101.
101. So now, my lord, they are taking the advantage of the, now says that they are not entitled to get bail because of the, my lord, that mistake get committed by the while acting by the petitioner, my lord. That cannot be a ground for my cancellation of bail. Your lordship kindly see all documents have been, my lord, placed before this one. This is not a case of extortion, my lord. Even your lordship, my lord, again, my lord, read the FIR, my lord. Any reasonable man can presume that this is a FIR, my lord, concocted FIR, my lord. The story mentioned is the, my lord, is, my lord, extortion money, can it be paid, my lord, to a, my lord, guy keeping evidence, my lord? That to a landlord-tenant, my lord. And that, my lord, now they are denying that, my lord, very important piece of, my lord, evidence. That is one of the renowned advocate of the Jorhat, my lord, after that, my lord, legal notice. But till today, my lord, if it is false, my lord, then why they are not taking action against him, my lord? So my submission before your lordship kindly see the modus operandi, my lord, very, now, my lord, how this, my lord, when we appearing, after getting the interim bail, I going to appear and I appeared, and that moment file an FIR and I was caught on another case, my lord, filed by the same petition, same complaint in my lord. And what type of this, my lord, without giving any notice, my lord, police has, my lord, arrest me, my lord. And that is why, my lord, while I was granted bail by the trial court, that was observation was made by them. That I placed before your lord. So, my lord, everything, my lord, placed before, and then case there also there, my lord. So considering everything, my lord, man, interim bail granted to me, my lord, maybe absolute, my lord. That is my submission. Already our statement has been recorded, my lord. And still I am the, as a tenant, I am working there, my lord. And my lord, regarding antecedent, my lord, he himself, he is not an old man, my lord. He himself in the extortion case, very few days back, my lord, the extortion case, under Jorhat PS case number 40 of 2024, he was granted bail by this honorable court. This is the order, my lord. Probably I have placed before your lordship, my lord. Talking about my criminal intelligence, since intelligence, my lord. But he himself is a, my lord, in a case of, he is accused of a extortion case, my lord. Granted bail by this honorable court. That's my submission.
This I can keep, or you want a copy? You want a copy?
We have the copy, my lord. Your chicken will have a copy.
These two I am giving back, but you don't have a copy, and we make a photocopy.
My lord.
Okay. I'll not complete the dictation now. I'll just reserve. I'll have to study and
My lord,
think about.
my lord, thank you, lordship.
I'll try to give it tomorrow. Or senior counsel. Assisted by someone for the petition. Case diary has been received. Place before the court. Third, the bottom for learned additional. Also heard PM Bora learned senior counsel. Assisted by. For the respondent or to informant. Arguments completed. Judgment / order is reserved. I'm reserving it.
My lord, I'm sorry, one thing, my
No
lord.
problem.
On my lord, while my lord, I was not there, my lord, I'm being told, my lord, when my lord, initial the application was moved, my lord. Then my lord, this honorable post asked the, my lord, other side counsel, my lord, who appearing, my lord, whether this notice has been given by you or not, my lord. That was, yes, he was asked to take notice on that, my lord, advocate notice. And he admitted that, yes, that's why my lord granted interim. So that was my lord, it is informed by my, I was not there. The vacation days.
Order is reserved. Yeah, so the case diary be written. However, since I am taking time, so interim has to be till the miles. The interim production granted to the petitioner. Originally by this order, right?
10-7.
10-7.
Mile.
10-7-25 shall continue till the disposal of this petition.
Mile.
Since I am taking time, so I'll try to give it tomorrow. If not this more I will come. Because it will need some. Not be wise to dictate it. Try to study these things. CD I can keep whatever. Oh. I'll just take a 5-minute. The AB. Okay. No, updated CDs. Sorry. You can get updated CD. No, Mr. Sutra, council. Portion learned additional people who submits that updated case diary is necessary. Accordingly, the case diary received may be sent back and the updated the case diary incorporating the up-to-date investigation may be procured again. List on 24.
With this is a lawsuit. This review petition has been filed for crossing of the FIR. Lordship, as per the last order of notice has been issued, and accordingly we have taken steps. And as per the office law dated 8/9/25, service report in respect of question number 2 and 3 is awaited.
2 and 3.
2 and 3 also. The informants.
I have structured progress for the number 2 and 3. Just received the petition. Also, I'll find the by or I'm like most by and maybe allow some time to file my petition.
Your good name, please.
D1000 Lordship.
So learned counsel for the petitioners. Who submits that steps on notice have been taken, already taken in respondent 2 and 3. So respondent 1 is presented by learned additional PPRR portion. Rasko, learned counsel, appears on behalf of respondent 2 and submits that newly entered appearance and filed the Okalat number 2. In a day or two.
Yeah. Understand, the request, page number 26 can be provided. It's not available in.
Okay, then provide. Page number 26.
26.
26 of, page number 26 in the bail petition. Within bracket annexer. Shall be provided to the newly appeared respondents. Also. The same is stated to be missing. List. List it after, we can list it for admission.
Admission after vacation.
Or hearing, should I admit it?
No, sir, no, vacation.
We can admit it. Is there any interim order?
Interim order is there also. Interim order dated 14/8/25.
It's pointed out by the learned counsel that there is an interim order, right, order dated 14/8/2025. So let us admit the matter. It will be better. The criminal petition is admitted for hearing. All the respondents have already appeared. The interim order, right, order dated 14/8/2025 stands extended till the next date of listing. The list for hearing, you want to date specific to
After the vacation.
no, but yeah, I can fix say it like that also. But you don't want a specific list after the autumn vacation. Considering it's a 25 matter, let us be realistic and fix it in November. So you can suggest a date in November.
Can it be on 4th November?
No, 4/11.
An application for suspension stay of the operation of the impugn orders dated 30/12/2024, 29/1/2025, 6/3/2025, 22/4/2025, 6/6/2025, 9/7/2025, and 5/8/2025. Passed by the learned chief justice estate, the Google issuing warrant of arrest against the petitioner. And I case. The bottom lordship, the respondent to file a complaint case under section 138 of the MA. And accordingly on 27/9/2019, the learned chief justice estate, the Google conjugated the petition with a fine lordship. And accordingly, the petition approached for the appellate court and the appeal was dismissed. And thereafter,
No, convicted.
yes, lordship.
He was convicted. Thereafter, appeal was filed.
Fine.
Appeal also dismissed.
Dismissed, lordship. And thereafter, he approached before this court by filing criminal offence along with the conditional delay lordship. But in the meantime, lordship, the civil mistake, the Google issue warrant of arrest lordship.
Because the impugned judgment was not stayed, so issued warrant of arrest.
Yes, lord.
What about the opposite sides? They have appealed. Private respondent,
We are on the formal party.
formal parties.
It's already state completed lordship.
Profula Gogoi has appealed. It will be necessary. NBW has been issued.
Yes, lordship.
NBW. So many NBW have been issued. Getting repeated,
Lordship,
repeated.
lordship, actually, page 7 and stated that according to the next date was fixed for appearance on 3/8/2024, and accordingly, 2 consecutive dates were passed. That is 3/8/2024 and 12/9/2024. But the complainant failed to take first step to the applicant petitioner for his appearance. And as such, the matter was fixed for
29/10/2024 for appearance of the applicant petition. On that day, the applicant petitioner filed a petition file number 4605 of the 2024 for his engaged counsel with a prior that the applicant petitioner had deferred a criminal revision petition. What is honorable to lordship? And equity powers allowed. Actually, the learned trial court not inform the same that I have to submit the court order. In paragraph 40, in page 49, lordship. Thanks.
It's 49.
Yes, lordship. Perusal of the case record revealed that the last order dated 29/10/2024, the convict was directed to appear before the court today and furnish appropriate order of the honorable court.
Right. But since the order was not received, so we should warrant. The only thing is that, what about the service of
Already received lordship. That is completed lordship.
service complete?
Yes, lordship. In IL lordship. On the lordship.
To be in the office note of the main petition.
No, IL lordship.
I number,
I number 1027. 2003.
it would be. One zero two seven. It was received by some, received by, Punchana S. Gogoi. Punchana S. Gogoi. That was indicating the relationship. Since. So can we accept? You have sent it by registered ID
Yes,
to
lordship.
the correct address,
Yes, lordship.
the correct address.
Five. Lordship.
Just a minute.
Case number 34, lordship. The address, same address. I have.
Proceed. So we can take up the, perhaps. We can take up the,
Because for this revision petition is concerned, the considering the IA will be required.
yes. So there are two IIS actually. So was the delay condonation has to be taken.
They have to delay combination. And now present I for all the suspension and state address.
Both IIS have come, right? Both IIS have come. Interlocutory application number 1027 of 2024. The applicant herein, namely MD Sareja Khan, was convicted under 138 of enact in CR case number 158 of 2015 by the learned CJM Dibrugarh by
Judgment and order dated 27/9/2019. The appeal file thereof was dismissed on 21/3/2024 by the learned session judge Dibrugarh in criminal appeal 35 of 2019. Agreed by the same. Next paragraph. The applicant as revision petitioners is seeking to file a criminal revision. However, there is a delay of 106 days for which an application has been filed under section 5 of the Limitation Act 1963 dash giving rise to the instant interlocutory proceeding. Third, learned counsel, your good name please? D.D. Gogol. D.D. Gogol. G.D. Gogol. The petitioner. For the applicant. Response number 1/state is a formal party. The complainant, Procedural Gogol, has been pleaded as complainant as respondent number 2. Steps of notice was taken by registered AD. And as per office note dated Six 9/2025 was received back upon service of notice being signed by one Nurchana S. Gogoi at the same address which finds narration in the cost type. So peruse the AD card. Service upon respondent number 2 is taken as complete. Should we wait for some time or it's possible? 6/9. 6/9.
Today's 9.
Today is 10.
10. 4 days.
We wait. I mean,
In the meantime, I mean, the suspension the
it has to be condoned. When was it signed? On the office notice, 6/9. The AD card may be earlier. Oh. There's a date of mention of 5th February this month, this year. So there is a seal of hyper. It will be dispatch date or receipt date.
1911. I think it's 1911 on 20. Yeah, lots of
Have a look, let's learn together.
lots of a complaint well known that I prefer this criminal revision petition.
He knows.
He knows. But I have informed CDM also.
Is the dispatch date from High Court or receipt date?
Receive that.
The AD card indicates important. The ID card indicates a receipt date of 8/2/2020. Not because of the services taken as complete. However, none appears today on behalf of the complainant. The main contention. Five two. In para 2 entry of page 4 of the delay condonation petition, the applicant has tried to explain the reasons for the delay. And I find that it is based mainly on the illness of his father. So, however, no medical documents have been annexed in support of the same. By the impugned judgments, the applicant has been convicted, has been sentenced. What is the sentence even? For conviction. Any change in the sentence or same? No, same words. Same. So from the beginning. Sentenced to pay a fine of rupees 3 lakhs as compensation. ID in default, SI for 6 months. In appeal, there is a provision for paying 20% of the amount, right? But in revision, is nothing. Yes. Because other things being equal, because that's why they have been forced to interim compensation provision has been made now, 20% appeal. Because generally, I don't think otherwise, it's not this case. Generally, it has been seen that they have constraints because of these factors. Tax court has been forced to impose these things actually, incorporate these things. That they have the complainant has to run for years. He lent the money, but he has to run. If Lordship allow, then I will pay also. 20% of no, I'm ready to. No, you try. See, you can settle at any stage. If you can work out a settlement, very good. That's okay. But since I will not direct something which is not there in the specific statute. The specific, 148, there's a specific provision has been incorporated. So that's why I asked. I might have missed. There's nothing like that as far as you know. In revision, there's nothing like that. Anyway. How many years will it take? Considering the fact that the revision petitioner is challenging his conviction under criminal law, I deem it fit to condone the delay so that the criminal revision can be accepted. IA number 1027 of 2024 within bracket delay condonation is allowed and disposed of on the aforesaid terms. It's gone. IA criminal 995. This interlocutory application has been filed. First, take this. Criminal revision 24. Then criminal revision has been filed by the petitioner, namely so and so. under section 430/442. BNSS read with section 528 BNSS. Seeking interference with judgment and order dated 21/3/2024. Passed by learned session judge Dibrugarh. Criminal appeal 35 of 2019. Whereby the judgment and order dated 27/9/2019. Passed by learned CJM Dibrugarh, CR case number 158 of 2015. Was upheld. Whereby the revision petitioner was convicted under 138 NI and imposed with compensation. Yes, compensation 3 lakhs in default SI for 3 months. 6 months. 6 months. The revision is admitted for hearing. You take fresh steps. Yes, take the petitioner shall take fresh steps upon the respondent complainant. Respondent number 2/complaint. This is the matter. This is the matter. The orders follow. On 6/8. 1911. IA 995 of 2025. For part 2 it's filed a criminal revision. But it has to be registered. Number is not there. It will be registered.
Filing number.
So sure. I cannot pass the order. No, I cannot pass. Oh, then it has to be a premature. So only then it has to be taken for this suspension. Let it get registered. We'll take it up on Monday. Yeah, will you be active? No, IA delay condonation is accepted.
Yes.
Now it can be registered.
Yes.
Right?
It can be registered.
After it is registered, the admission.
Yes.
And then suspension. Otherwise, the sequence will not be correct. In districts, in many districts, they number the petition. Actually, that is not correct. Before condonation, the case is not born. Yes. That is not born.
Suspension. I'm not knowledge. Just after we have to file this main case.
Yeah, that's why. Yeah, that sequence. Delay condonation, main petition admitted, and then in that suspension of sentence, right? So we take it out. In that IA only, if delay condonation IA only we can mention. The criminal petition may be registered. The criminal petition may be registered in criminal revision petition may be registered and number and put up for admission. On list on 15/9, along with IA 995 of 2. Thank you. So this will the IA supposed to. I 1027 disposed of. Allowed and disposed of. So criminal connected criminal revision, the registered number fixed on 15/9 or 17/9. Let it be on 17/9. 17/9 along with IA criminal 995. of 23. Clear? Orders took a lot of time to do. Pick up a hearing.
Wait, please, ma'am. Pursuant to the last order passed by this honorable court, we have taken steps upon the respondent number 2 to the POCSO matter.
Yes.
My lord, may kindly peruse the office note dated 8/9. Await service report. Date may kindly be fixed.
Scan report has been,
PCR stuff.
scan copy has been.
Like the
Peruse the last order date 22/8/2025. As also, and also, office note dated 8/9/2025. Dash, which indicates that service report with regard to R2, respond number 2 is awaited. Semicolon, though. Scan PCR pertaining to Mikir Bheta PS case number 26/25 has been received. Now, you'll take instructions.
Right.
The learned additional PPR portion may take instructions regarding the service. You'll take instructions.
date may kindly be fixed.
Huh?
Date may kindly.
I'll fix it.
Right.
Once the service is complete, we can appoint an amicus.
Yes, yes.
Then we can proceed.
Yes.
You service, you can service. How much time?
Any date before, okay.
Before that. Nineteen? 19/9. You have something? That was time being.
Yes, the matter was time being 56 and 57, Lord. So at the time the CI council was not there. Now still she is not there. Can it be taken up tomorrow, my lord?
Tomorrow, we can try. Tomorrow I've seen only one hearing, there but only one hearing given. Just sort of got this. I was even planning to take try one hearing to 2014 matter, but not touch admission also. So it's time, bills also take time. Well, we can try fix it. We can
Tomorrow, my lord. What the matters?
try.
Must-
It is at the stage, it's a bail,
It's a bail hearing, my lord.
bail here.
Your
Can, I mean, the supply
earlier-
list. Supply list.
Possible.
Lordship, item number 15, there is some urgency in the matter. What has happened in this case, there is the PRC order, there is an order passed in the PRC case. That has been put to challenge before this honorable court. Now, prior to that order, Lordship, there is an order of this honorable court, the coordinate bench, directing the concerned trial court to adjudicate the entire issue with regard to one application pending to this trial court with regard to the PRC matter within a period of 1 month. Now, 1 month has already elapsed. Now, since this order is creating some sort of confusion for the learned trial court, because the one order, this direction is given to dispose of the matter.
And
within a period
another
of 1
order.
month. And again, this stay order is in operation.
Stay order. Oh,
Yes,
oh.
stay order is in operation. So my, there's extreme urgency in the matter, Lordship. It will be taken up on Monday, Lordship.
Then, okay, it can be taken. up
Lordship,
on Monday.
only a limited prayer, Lordship, because of the paucity of time. Can it be fixed at 2, Lordship? Otherwise, it will be very difficult because on 2, 3 occasions, these measures have been listed. But because of paucity of time, it will not be taken up, Lordship.
Monday we can try. After
At
the second
2,
half.
Lordship, at 2, Lordship, can be fixed at 2.
So in that case, what can be done? You know, for two
No, Lordship,
conflicting
this
orders.
particular order, what has been put to challenge, certain things have not been clarified before this honorable court. So I've given certain certified copies in the last occasion, probably these things are.
So you are seeking vacation of the stay.
Not vacation, is it, Lordship?
Modification.
I'm just praying for disposal of the entire criminal.
On Monday.
Enter criminal. It will be disposed of, it was very small order.
Small
it
issue.
was transferring the case from one court to another. That is the issue that has been taken into account.
In that case, how about fixing it on 16th, hearing day?
16, at 2, Lordship,
Can try.
at 2.
I have not been able to start even hearing days admission before 8:30.
Exactly.
So let's see. These are the challenges. At 2,
At
let's fix it at least.
Then
Then
may
continue. There is the only time. Interim may continue. Okay.
16 at 2.
May I please?
Positive.
Oblige, Lordship.
Also, item number 13, there is an interim order also. That should be continued also.
Likhilo. Paucity of time will not be taken up. Interim order shall go.